I'd like to remind you that we are being broadcast online and throughout Parliament buildings. I just want to welcome those people watching online today. So if you can please ensure that your mobile phones are muted, and just to remind you that no recording or photography of the meeting is allowed. Okay, I'm just going to proceed with the agenda. So we have one apologies today, and that's from Anya. We have two ladies online, Sinead and Carol, and I think we're still waiting for Claire to join us. Hopefully that won't be long. Okay, any declarations of interest to declare, members? Okay, so in terms of Chairperson's business, just to let you know that the Deputy Chair and I, with the support of the Clerk and Assistant Clerk, met with the First Minister and Deputy First Minister earlier this week to get an early briefing on the bill that's before us today. And I think a note has been circulated about that meeting, so if we're content, I'll move on. So then last week, as you'll recall, I had to leave the meeting early to catch a flight to go over to London for the Interparliamentary Forum in the House of Commons. So this meeting went ahead. It was chaired by Simon Hoare MP, who's chair of the Public Administration and Constitutional Affairs Committee, and it was attended by representatives from the House of Commons, House of Lords, Northern Ireland Assembly, Scottish Parliament and Welsh Parliament. The forum heard updates from each legislature and discussed issues of common interest, including intergovernmental relations, the nature of devolution and the legislative consent motion. So I think we're going to do quite a wee bit of research, and our next forum meeting in Wales in the autumn will hopefully bring together actual representatives from the governments from each of the legislatures. So that's going to be quite a hefty one to try and pull together, but it's very worthwhile. Okay, so media queries then, just to advise that you'll have seen recent media coverage following the introduction of the inquiry and redress scheme on Monday, and I and the Deputy Chair have approved the following lines to take in relation to the media queries prior to the second stage, and these have been tabled, hard copy on your tables if you are content to sign those off today. I'll read them in the record for the ladies online. So the committee welcomes the introduction of the inquiry (mother and baby institutions, Magdalen laundries and workhouses and redress scheme bill). Members recognise the significance of this legislation for victims and survivors and the key elements it contains. The bill is scheduled to reach committee stage on the 25th of June, and at that point members are committed to undertaking thorough scrutiny to ensure it delivers meaningful outcomes for all those affected. Has anybody got any changes they'd like to propose, or are we content with that?
Fine.
Yeah. Okay. Thank you, members. We can proceed with that. Thank you. Okay, so just to advise then that the committee team are working with Assembly colleagues in engagement and comms to prepare a plan for the committee stage, which will be brought to the committee for approval at its meeting on the 2nd of July. Okay. Moving on then, draft minutes. You'll find these on pages 6 to 17 of your pack. I'm just going to ask members if they're content that these are a true reflection of the proceedings of the meeting held on the 4th of June 2025. Anything to raise? No? Okay, thank you. Okay, matters arising. There are no matters arising. Okay, so we're going to proceed then, thank you, with the oral briefing from departmental officials. So, on the inquiry and redress scheme bill. So members, you will find the clerk's brief on pages 20 to 21. You'll find the TU press release on pages 5 to 6 of the table pack. You'll find the bill itself on pages 7 to 50 of the table pack, and you'll find the explanatory and financial memorandum on pages 51 to 77 of your pack. Okay, so I'm just going to seek, before we introduce our panellists today, I'm just going to seek your agreement for Hansard to record this oral evidence session. Everybody content? Okay, thank you. Okay, members, the purpose of this session is for us to receive an oral briefing from departmental officials on the provisions and the EFM of the bill. Just to remind, the bill was introduced on Monday of this week, first reading, and second stage is scheduled for next Tuesday, the 24th of June. And committee stage then will, if that passes, will commence on the 25th of June. Okay, so you're very welcome to the meeting. So we've got Elaine Allen from the Redress team, Martin Carey, the Programme Director, Michaela Jordan, Programme team, and Francesca Murray from the Inquiry team, all from the Executive Office. Okay, so you're all very welcome back. If you'd like to go ahead and make some opening remarks. Thank you.
Thanks, Chair, and thanks for the opportunity to come before the committee so soon after the bill's introduction on Monday and to talk through the explanatory and financial memorandum. I suppose, first of all, it's taken us a long time to get to this stage, but we're pleased that we've got to introduction, and we want to acknowledge all those who responded to the public consultation, especially victim survivors. This is part of a much wider process of work, which is outlined in the design panel report, which included a two-stage investigation and a two-stage redress. So this legislation fulfills the second stage of the investigation and the first stage of the redress process. That in itself is quite novel and innovative, and I think this is a key element, is to try and get a simple and inclusive standardised payment out to people as early as possible. That being said, this is a very complex and sensitive piece of legislation. It's much more complex probably than we first realised, and I think there's many moral, legal and financial implications to work through. The draft bill, which is in blue paper here, which is just that, it is a draft, and I think it's important that we listen to views of people throughout the process, and we do appreciate that some victim survivors were disappointed by some of the decisions outlined on Monday, and we want to reassure that there was careful consideration by both the executive, and I'm sure there'll be the same careful consideration by the committee, and we look forward to supporting the committee with that work. Chair, with your permission, I was just going to cover a little bit about the starting position of the EFM and then the inquiry, and then do you want me to stop and then we can cover the financial and redress?
Well, I have my questions broken down into different sections, but sure. I'm not sure what other committee members want to do. Do you want to hear everything at once, or do you want to do inquiry and then redress, basically?
Might be easier.
Go ahead, Carol, I can't hear you, please. Sorry.
Sorry, Paula, could we break it down into sections because it's quite big?
Yeah, okay. Well, yeah.
Okay,
Thank
thanks.
you.
So I'll just, I suppose, a couple of the key things just to highlight in terms of the EFM. I suppose paragraph 9 of the EFM outlines really what the legislation is trying to do. So establish a statutory public inquiry, and then secondly a statutory financial redress scheme which focuses on the standardised payment. So in terms of your bill itself, that's for the inquiry, it's basically providing clauses 1 to 29, and it's basically setting up for an independent investigation with statutory powers, including the power to compel evidence, which is in clause 16. So, and then an initial redress payment, which is basically our scheme, which is estimated to cost 58 million, and that will support over 6,000 claims, and that will really support three main cohorts: people who were admitted into institutions, that would include birth mothers and people admitted to Magdalen laundries, children, now adults of those birth mothers who were in those institutions, and then posthumous claims. So we expect about 4,500 claims to be in relation to the first two cohorts, the persons admitted to an institution, and then children, now adults, and then about 2,000 relating to posthumous claims. And the final thing that the bill really provides for is a redress service, so an independent body to provide and to administer payments. So just in terms of the consultation, we've outlined on page 4 of the EFM, I suppose, the 269 responses, and in paragraph 22 we've tried to outline some of the key changes from the consultation. So one of the key themes is outlined there in A, which was simplifying the eligibility criteria. So previously we had a 24-hour admission, and so I suppose we had actually quite a lot of evidence to say that was going to be difficult to verify, so we've simplified that into just purely admission. We've amended how posthumous claims are made, and that will allow for separate and independent claims, so that would be a £2,000 payment rather than there was real concerns around privacy and some of the concerns around that. And then extend the redress service. For originally we had consulted that it would be open for up to 3 years, and we've extended that up to 5 years. And then the addition of a victim survivor advisory panel as well. So, and some reassurances, I think it was been raised in this committee previously as well, about the role of the state actors, and the role of individual experiences, that they would be encompassed within the bill. So I'm going to hand over to Francesca, and she'll maybe walk a little bit through the inquiry. I'm also conscious there's some outstanding queries we have from previous evidence sessions, which we're happy to cover as we go through the process. So,
okay.
Francesca.
Thank you, Martin. I'm going to cover the inquiry side. The EFM covers 29 inquiry clauses in total, which relate directly to the inquiry. To summarise, the proposed inquiry will have powers similar to the Inquiries Act 2005, including the power to compel, which is in your clause 16. We should start by saying that the vast majority of the clauses in the Inquiries Bill closely mirror the Inquiries Act, which is as recommended by the Truth Design Panel report. There are standard clauses for inquiry, and the main purpose is to set up an inquiry that's independent, impartial, fair to all concerned, and allows an examination of the facts. There are 4 clauses at the start of the bill, clause 1 to 4, which deal with the focus of the inquiry, and this would be additional material to the Inquiries Act. The period covered for the inquiry would be 1922 to 1995, and if we can look at the effects after 1995, that would be contained in your clause 1. And some also allows for some flexibility in relevance to the terms of reference to the chair also. So the bill has scope to allow the chair to look at ongoing effects in the period. This was requested by some victims and survivors who were concerned that the impact of their experiences throughout their life might otherwise be missed in the inquiry. The chair will have the flexibility to make any recommendations they see relevant, even if these are not required with the terms of reference, and that there's reference to that in clause 18. The next point is that the focus of the inquiry will be on systemic failings, and this is by the institutions and their pathways and practices, including public bodies and other persons and bodies, and this includes the role of the state. Examination of pathways and practices may include the routes into the institution, i.e. the admission pathways, and the various routes out and departure destinations. It includes the full web of connections to the institutions, to include GPs, social workers, links to the state, links to how these people have maybe entered or left the institution. And it also would look at the placement of children on their departure for adoption, fostering and other care arrangements, but does stipulate without not to the parent of the child. The inquiry can hold persons accountable, but within the limits of the Inquiries Act. It cannot determine a person's civil or criminal liability. That would be a matter for the courts. With respect to human rights, human rights is central to the implementation of the recommendations of the report, and in practice this means procedural firmness, promptness, accountability, openness to public scrutiny, and the involvement and support of victims and survivors. It is important that an independent investigation, that there are clear principles for the inquiry to follow and make sure it's fair and is meaningful and is centred around the panel principles. Inquiry will have a framework which will be clause 2, 3 and 4, and will propose things that must be in the terms of reference. That relates back to clause 2. But there will be a separate process to finalise the terms of reference, which will be informed by the chair themselves and anything that comes forward from the recommendations and findings of the independent panel. The reason for the full terms of reference not in the bill is that we do need to consult those people, but we thought it was important to have the key terms within to give it a focus and also to allow assembly scrutiny. Another addition from our consultation and something that has been included in the bill at clause 10 is the introduction of an advisory panel. So the chair will have the power to create a victim and survivor advisory panel for the inquiry itself. The inquiry will be inquisitorial and not adversarial, so there will be no cross-examination. Thank you. Okay. Okay, thank you. Sorry, I just spotted something. There's a sort of, you need to read these things over and over again, don't you? Okay, I have a few things here to start. Okay, so the name of the inquiry, so clause 1, section 2 on page 1 there, the inquiry is to be known as the Truth Recovery Public Inquiry into Mother Baby Institutions, etc., right? Why do we need to add truth recovery? Is that not superfluous? When we've heard from victims before around HIA, they said that it didn't really mean anything to them, and I'm just thinking maybe that's something that doesn't need to be included, okay?
Yeah.
I don't think you need to respond to that, just put that on record. Okay, so The inquiry panel then, clause 5(1) A or B, page 3. So the inquiry is to be undertaken, is what it says, to be by an inquiry panel consisting of either a chairperson alone or a chairperson with one or more other members. And then the EFM says it's about providing flexibility, what is appropriate to the circumstance under investigation. Just wonder why that decision hasn't been taken yet.
Yeah.
Have you engaged with the Lady Chief Justice and members of the judiciary around this?
Yeah, we have. I suppose, Chair, the design panel report, which is here, outlined a process for a designate chair, so it can't formally be appointed until the legislation is passed, but there's precedence with HIA, so George Hart was appointed prior in a designate form and then formally appointed once the legislation was passed. The 5(1) is basically some inquiries have just a single chairperson, so Baroness Hallett in the COVID inquiry as an example, I understand it doesn't have an inquiry panel beside her. She just relies on assessors and other advice, whereas other inquiries will have a panel. In Northern Ireland we generally have panels. We normally have a 3-person panel. There is work ongoing to start. We've received nominations from victim survivors for names, and there's also nominations from other sources, and we're going through a shortlisting process at the minute.
Okay, but so my point is, does it need to be on the face of the bill?
So I suppose all this is providing is just a power to do this,
Okay.
and then it's up to the inquiry chair then to decide effectively if that power, if they want a panel or not.
Okay.
So, yeah.
Okay, so page 3 then, definition of relevant persons. So clause 4(1)B, and it's in relation to prescribed workhouses. So I think that there's a missing subsection here, and I think it's really important that we see it in the face of the bill, and it's about women or girls who were impregnated by the staff of the workhouses, and who were supposedly under the care of the
Yes.
workhouses.
Yeah.
So that is another subsection of additional layer of abuse that women and girls endured. Okay,
Yeah.
don't know how you're going to word it,
Yeah.
but there is a subsection of, or not a subsection, wrong. There's a section of the women and girls who were actually impregnated,
Yeah.
and that's why they went from the workhouses to the mother and baby institutions. I suppose there's another section there that I think is missing, and I want to know whether you have grappled with it too, because I don't know how it would go in there. But it is the babies who didn't make it,
Yes.
the high levels of infant mortality,
Yeah.
and how the inquiry or other, how their story can be told
Yes.
in this, because they're still relevant persons, even
Yes.
though they maybe only were alive for a day.
Yes.
So I'm just raising that as
That's a fair.
they are relevant persons. Okay, submission of reports, and I've just quickly scribbled that down there. So clause 18(1)B, page 11,
Yeah.
the chairperson must deliver a report to the First Deputy First Minister, and then the B relates to the recommendations of the inquiry panel where the terms of reference required to make recommendations.
Yes.
Would that not be the case that an inquiry would be as a matter of course or fact?
It would, and I suppose some of that, I think, Chair, is coming from the Inquiries Act. There's also a provision under that, which is subsection 2, which also, so it basically requires that the Inquiry Chair does make recommendations where they are required to do it, but it also, in subsection 2, it doesn't restrict them. So this is a really important aspect, that an Inquiry Chair can, if they deem it relevant to their terms of reference, they can report on whatever they like.
Okay.
And recommend. And I think that if we look at the HIA example, that was definitely the case. I think Judge Hart basically looked at, he had a terms of reference, but he also then, if he felt it was deemed relevant to his terms of reference, he also provided recommendations in relation to that. So it's it's both and.
Okay.
So.
The last one then, really, I just scribbled down there as you were speaking, Martin, when that was about the time limit for applications, then clause 32 to page 18. So it says 3 years, and then it says may by regulations be extended to 5 years. So I think you'd indicated there that it was 5 years, but also why would you put a limit if it's just the regs that would extend it to 5 years? In other words, you don't even need to stipulate the number of years. You could say by regulations could be extended, because we might have another pandemic, or we might have some collapse of the assembly or something.
Yeah.
I think you might just be binding too much to say, to include a specification of the extension time.
Yeah, I suppose You're right there, Chair, in that what it says in the face of the bill, it's basically a 3-year plus 2 year, so up to 5. In the original consultation, we had it as a 2-year plus 1, and we got, I suppose, feedback from the consultation that that wasn't long enough. Make sure that people know about it, access it, and your point there is you're saying you may not even need the
just by look at extend,
regs,
yeah.
So, and there is that power, I think, in subsection 2, and I think there's a delegated powers memorandum which is, if it hasn't been received by it, will be received, and that's one of the ones that's by negative resolution at the minute. So that might be something that
We were talking about that earlier, weren't we? Yeah.
about whether that's.
Okay.
We're sort of walking through this and we're thinking that there is an element of assembly, there is resources and time around that as well, so that might be consideration for the committee whether that's appropriate or not. So if it should be a draft affirmative or negative. So.
I was leaving that technical one off
That's
today.
okay.
I've had enough questions.
Sorry, yeah.
No, thank you. That's all for me. Does anybody else want to add any of that before we go on? No. Oh, right. So no, I'll go to Deputy Chair first. And then,
thank you, and thank you very much, Martin and the team, for not only the work that you've done in preparation for this as a bill, but the way in which you met with the Chair and I to take us through some of the highlights, important sections of the bill prior to its first reading. But in addition to meeting us, you also met with some of the victims groups.
That's right.
Can you tell us just what their reaction was to their first sight of the bill?
Yeah, I think, Stuart, we met with victim survivors last Thursday just to outline sort of the process in terms of what would happen from Monday onwards and what events and support would be available on the other side. Ministers met with victims on Monday morning and outlined some of the policy decisions that would be in the bill. I think the initial reaction, Stuart, I think there was a lot of disappointment, if I'm honest, and it centred on 2 or 3 sort of key issues, which maybe Elaine will cover as part
the
of
second part.
The second part. Yeah. It was not exclusively around redress, but a lot of it was related to redress, Stuart, and we're happy to outline some of the I suppose some of the challenges we faced and ministers have faced around that, but that I would say it was disappointment that was the overarching. Don't know how universal that is, but I just think that was the instinct on Monday. I don't know, is wrong.
Well, I think it's worthwhile saying that we have received some correspondence from some victim survivors who acknowledged as well the disappointment that had been expressed at the meeting by a number of the other victim survivors, but who welcomed the bill and that we'd reached this important milestone, and they were, looking forward to seeing how they can work with committee and as the bill progresses through the Assembly. So we have had some positive feedback as well, I must say.
Yeah, and I appreciate that.
Yeah.
But to what extent then are you prepared to work with those? Because I think the ultimate fear would be that people would refuse to engage with any of the process and may just simply go down an alternative judicial route to redress. So how willing are you in terms of a team to ensure that we explore all of the avenues to make this as an inclusive process as it can be and to meet those fears and concerns?
Yeah, absolutely. Sure, we're very happy. This is, we did say both what we've said throughout. This is a draft bill. It is really important that sort of there's a political and an assembly process around that, and this is about balance here. It is a 2-stage redress process. There is a second redress scheme to come, and I suppose one of the limitations with a standardised payment is about trying to provide a common basis and trying to provide something on an admission based versus those individual experiences. A standard payment isn't going to reflect the experiences that people have had in institutions, so that is a sort of key difference. But there's also lots of different issues as well, Stuart, around posthumous claims, as an example. While I think maybe the separate and independent sort of maybe cross off some of the privacy issues, there's still I suppose concerns around some of the decisions that were outlined. So,
And sorry, if I can just add, as with the process that we kind of undertook following the consultation, or during and following the consultation process itself, we have offered victim survivors that we will meet people on an individual or a group basis. We're planning to have clinics just to ensure that everyone has a good understanding of what the bill does, because we're a bit unsure ourselves at the minute if everyone does have a complete understanding. The meeting on Monday, there wasn't the opportunity to really go through the bill in detail, so we want to give people as much opportunity as possible. And also, as a group, victim survivors are keen to work together to kind of coalesce and come up with ways, either individually or as a group, to make representations to the committee. We've got plans throughout the summer to work together and with support as well for victim survivors to aid understanding.
But in reality, no two stories are the same, and they're very personal stories. Two very brief questions. The chair raised the issue of the admission pathways and also girls impregnated by workhouse staff. Those are important issues. To what extent are you satisfied that the inquiry will be able to reach out to the very edges of those types of concerns, or indeed concerns that have not been identified yet, but may be identified as a result of the inquiry? Is there sufficient scope to allow for either something new or for those very difficult issues to be addressed seriously in respect of this? And I have just one more question.
Yeah, I suppose, Stuart, that clause 18.2 is very helpful in terms of it enables a chair to have some type of flexibility outside their terms of reference if they feel it's relevant to their terms of reference. So it is given that sort of discretion to the chair. And Francesca said about a temporal period as well. So basically, if there's stuff that happened outside the 1922 to 1995 period that they feel is relevant, and just to assure people, I think that was one of the concerns around the consultation. People thought, so there's lots of Article 8 issues around a person's right to family life and records. So that is something that is happening today. That is a human rights issue today, and that could be covered within the inquiry. So it's just trying to assure you that there is sufficient flexibility for the inquiry to examine, and particularly around spotlight cases. This is something that came out in the consultation. And it was an excellent point. People said, we're not sure if this is a systemic or these things happen to loads of people, but by an individual documenting and providing their testimony that this happened to them, that might actually enable other people to say, well, that also happened to me. So the importance of sort of individual experiences being reflected in a systemic way as well. So this is this is really a framework for an investigation, and there's lots of powers there that can be used. So hopefully that answers your question.
It does. You'll be aware that there's serious concern around the issue of contribution to the ultimate compensation. And in a sense that takes me back to the admissions pathway.
Yes.
Some admissions may very well have been to the individual, either informal or just personal to them.
Yes.
But in reality, in the background, that admissions pathway may very well have been part of a network of people who were able to talk to each other, but for whom the victims had no knowledge that there was a network in the background. And that may actually draw in other, I'm thinking particularly of church institutions that have not been identified as yet, but were implicit in recommending that so-and-so go into an institution. Can we be sure that they will be drawn into that element of potential compensation? And that then really leads me to the final question that I have, and it goes back to this fundamental question of the failure to date so far across the UK and Ireland to effectively draw in institutional responsibility for payments. We are not going to let go of this. We will be seeking our own independent independent legal advice in respect of this. And if it is, and I set this out as a very clear warning, if it is humanly possible and human rights compliant, this committee, at least this member of the committee, is determined to see that we find a route through that to make those who are responsible pay for their responsibilities.
I mean, I agree with all of that, so I don't know, there's not a lot. I suppose Stuart, I think the commitment is very clear in terms of trying to get contributions of institutions or other bodies who are responsible, and that includes states' role.
Yes.
And the EFM, the financial effects, we referenced that there has been engagement, I suppose, in the period post-73 as well. In relation to the direct rules, so that engagement around sort of NIO, Treasury, there's been no agreement in relation to that, but that's something that's been pursued as well. So.
Thank you,
Okay,
Chair.
thank you. Timothy, please.
Thanks very much, Chair. Afternoon all. I suppose I want to start on terms of reference 2.2, where there were any systematic failings by prescribed institutions. So on that, obviously the inquiry cannot determine civil or criminal liability, which is understandable. But I'm very conscious throughout the duration there may be evidence that comes forward, and I'm hoping this is something that has already been picked up and there's a process in place. But I'm looking for a sound commitment that there's a process in place where evidence that may be presented to the inquiry will be referred to the PSNI, to ensure that there's no breakdown of communication here. We've heard previously that PSNI, there's an officer dedicated and working with the team on that, but I want assurance once again at this stage that when there is evidence comes forward, that there is criminal activity identified, that will be robustly investigated.
Yeah, so I'll maybe hand over to Francesca, but the short answer is yes. So.
Yes, generally within the inquiry, the inquiry chair will bring about protocols and things within the inquiry, which will all be evident on their website and available for the whole public. And one of those protocols in general, and if you look at the other inquiries, you'll probably see them on their website, is usually a memorandum of understanding with the like of the PPS and the PSNI. So there is that mechanism that should there be any criminal activities that are emerging, that then is reported forward to the PSNI and the PPS to investigate and see whether there should be criminal charges brought. So that's sort of a matter of something that an inquiry would generally do, and that is something that we have and we are imagining that will happen bringing forward. But those protocols will come with the inquiry chair. But it is something that we will, there will be discussion had with them, and it is something that is commonplace. So we don't envisage that's not going to be the case, Timothy. We can't sort of preempt what the inquiry chair will say, but it is something, if you want to look at the other inquiries, there are similar things out there. I mean, I think the Muckamore Abbey Hospital inquiry would have it on, their key documents would have a memorandum of understanding with that same aspect, that they have an obligation.
Yeah, I suppose just to add those processes, so those disclosure protocols. So if we look, people are coming forward to provide evidence to the independent panel. At this point in time, those disclosure protocols are in place for the non-statutory, so they will be in place for the statutory. So that basically means if someone discloses a crime in the course of evidence, then there's clear protocols that those are passed over to either the PSNI or the PPS. So.
You may find as part of the inquiry where people that haven't engaged the evidence, and we've already heard touched upon, the evidence that is brought forward identifies other feelings. I'm very conscious on the back of this that there could be a lot of civil cases for damages which is sitting outside the inquiry. What thought process have you given to that?
I suppose what inquiries normally do is to examine the facts based on the written or oral evidence that comes forward. Those are, if you like, sort of separate processes to civil processes. I suppose in reality, Timothy, some people will maybe look to a public inquiry that is established an evidence base in order to support a civil claim. That sort of would be not uncommon, but they are separate processes.
We had heard the term power to compel.
Yes.
It's something we've talked about at length in this committee. Essentially, it makes me very uncomfortable, because when we have sought what our powers could be and to compel the institutions to come in front of this committee, we have never followed through with, I think it's section 44 to come. So when I look down through it from previous committee appearance, where there's a number of them where we had sent an invitation, one had requested to come at a later date. 3 of them ignored our request, and 2 of them were uncommitted. Where I'm going with that is touching very much on previous speaker, in that I want to ensure that those institutions are held responsible. When we haven't progressed with the section 44 to bring them in front of this committee, what confidence can you give me that they will be made to come in front of the inquiry?
Yeah, I suppose typically section 16 outlines some of the powers and duties that are required for individuals to either provide written or oral evidence to the inquiry, or other documents. But there is also an offences element to that clause, I think, as well. So 23, yeah. So clause 23, it's an offence that if someone doesn't comply with clause 16, there's then a sort of legal process that can be sought through at that stage. So,
in the past, when there has been conversations and communication regarding contributions, I've been very critical regarding the independent facilitator and his role in that, where I was looking through previous minutes where it talks about a delicate stage, and really putting us off pressing for these organisations to come. That doesn't wash with me. We need to do all we can to ensure it shouldn't be the state paying for this. Yes, the state's responsible for a large element, but these homes that have shunned this committee in the past, need to be brought, need to be given evidence, need to be held to account. And I'm really putting the onus on you to make sure when this comes out the other end, it's front loaded, we're getting the money that they should have been paying. This isn't a case of, will you give us some money to pay towards it? No, there needs to be something in the bill, and I think from the committee's discussions previously, we're very, very keen that there's an amount put in, or some sort of framework put in, that the institutions do have to pay, and they can't shirk the responsibilities on that. Advisory panel 10.1, there has been concerns in the past regarding some of the within those that have come forward to give information. Can you expand any on that, or give us some comfort of how that will be put together, and that will take in a wide range of views and opinions?
Yeah, I suppose this power, I think it's really keen that there's this is for the inquiry chair to exercise that power, but my view is that sort of detailed consultation in terms of how that process would work, that make sure that it's representative, that it's clear in terms of the what they're there to support and advise on, and what is outside their sort of advisory role. I think we've looked at other advisory panels. So there's the independent inquiry for child sex abuse in England had an advisory panel. I think it was a 7-person panel with a wider panel of 10, or in other processes maybe 10 or 15 people involved in that process. So there are some sort of precedents there as well. This is quite a difficult an advisory panel. Just there are lots of different experiences in this process, and having something that can reflect all those experiences is going to be a challenge. But I think equally it should help inform the inquiry's work and support the inquiry to deliver, particularly for victim survivors. So,
what input will the TO have in that, or is it down to the chairperson to really formulate that and ensure that you mentioned the 5 or 7 or 10? Reading down through here, I don't think there's any number.
There's no number specified, Timothy, but it will be for the chair of the inquiry to determine that, but I think looking at other models, you would sort of think it would be somewhere between 5 and 10. That would be my instinct. I don't know. So, but
Sitting with the chair, it's obviously going to be independent, and there's not much of an input from the department.
no, there won't be. I mean, I suppose it's maybe a slightly separate point, but the inquiry, and we'll maybe come on to some of the financial effects of the bill. There will be staff who will have to support in a secretariat role to the inquiry, but the inquiry is a separate entity and body, so they will take direction from the inquiry chair, not ministers. But some of the staff within the inquiry could be civil servants, so that's sort of the model. So,
Thanks very much.
Okay, thank you. And Brian, please.
Thank you, Chair. In terms of the scope of, I think we're coming on to the redress scheme, Chair,
Yes,
already.
after, yes.
Yeah, but I will ask
The
this
inquiry
question.
now.
In terms of the scope of the inquiry and the redress scheme, are they the same in terms of, well, I'm referring to Schedule 2, the list of institutions.
that's right.
So is the
They're different at the minute. So in terms of what Brian, really what the investigation provides for is a framework for investigations with 4 institutional types, and then there is a subset of those institutions where we've got evidence from the Queen's UU report for detailed sort of institution by institution within specific time periods, and that's been the basis for the standardised payment. So, and there is a power to add to that list. So it's sort of what this means in practice is those 6,500 claims I talked about at the start of the meeting, those are all tied to named institutions and named periods, and that's outlined in, I think, Schedule 2 maybe of the bill. So they are slightly different.
okay? So the inquiry will be broader.
The inquiry at the minute is broader.
Right. Right. Because there's mothers and babies institutions, Magdalene laundries, workhouses, and then I think it talks about other institutions. Okay. So, well, in terms of the scope of the inquiry, do we know how many other institutions there are that will be included in the inquiry?
So I suppose that'll be driven by, I suppose, 2 main factors, Brian: the consultation with the chair, and then also by the evidence, the findings and recommendations from the independent panel. They have tried to examine a large number of institutions, so there is a wider list than what they examined previously in the Queen's UU report. So there could be another maybe 10 organisations, just off the top of my head. There could be more, Brian, that potentially could be part of the investigation. So
I think there's 11 on that list. So you think there's another 10?
there's another 10
potentially in the inquiry.
And if you sort of think about workhouses, so workhouses obviously were location based. So in the period from 1922 to 1948, there was 20 workhouses which were in operation. So you could have 20 on workhouses alone as well. So
Right. And well, again, I'll ask the question now because it duplicates between the two. The relevant years, I take it there's a rationale for, or in some cases it might be those are the years the institution operated, but
that's right.
in some cases is there a cut-off year in terms of how the institution operated?
Yeah, that's right. So some of the institutions will actually still exist in some form today, but in a different function. So, for example, I think one of the institutions is now, I think, either a health centre or a homeless centre. So there's different functions throughout the time periods. So we've tried to tie all the dates back to the original QUB Ulster research, which examined the experiences within those periods. So
Right. I mean, and in that, the university's report, I mean, we've mentioned it before, it is disturbing when you read about the wide range of circumstances in which people were sent to institutions. Sometimes it was, well, unmarried mothers or unmarried pregnancy or other pregnancies that somebody wanted to conceal.
that's right.
Or some cases people are being sent for their own protection,
Yes.
or some are being sent as some sort of punishment or sentence, or sent because of mental health issues. And it just seemed like
such a huge range and inappropriate for all these different circumstances, and quite frankly, virtually none of them to do with the welfare of the women themselves,
Exactly.
or their babies in those cases, and of course the coerced adoptions, and often against wills. So, will the inquiry? Will it be investigating the full range of circumstances? It will not just be focusing on mothers and children circumstances.
Yeah, maybe. Do you want to
Well,
answer?
when we talk about pathways and practices, it's about how, as you say, there was a various range of people who maybe were entwined or involved in the admission of that person, or why they were admitted in an institution, and then again, how they left, where did they go, what happened, as you say, maybe where has their child gone. That is all part of the pathways and practices aspect of the the admission and departure, and that would look at how it gives the inquiry the opportunity to look at how that happened, and maybe those things that were common or not common as it may be, and be able to report on that, and that's how that encompasses those pathways and practices.
Okay. And last question is, obviously there's good groundwork in the university's report, but will it just be seeking to delve further and take more evidence, or is it seen as a good foundation?
It is, yeah. It's a sort of institution by institution analysis, but there's also contextual and thematic, and that'll be built on then by the independent panel who've got a broader range of experiences of people that have come forward, and that will also examine different institutions as well, and some of the gaps, I suppose, that the original research highlighted were around baby homes, were around workhouses themselves, and around something called private nursing homes as well. So those are 3 areas that hopefully the panel will be able to provide.
Give me that again. Please.
So it was baby homes, private nursing homes, and then workhouses.
Right.
So.
Okay, thank you. Thank you, Chair.
Brian. Carol, please.
Thank you. Thanks very much for all that. I'm not going to cover the points or the questions that other members have made. And just to say, I think we all want to make sure the survivors and victims get what they're entitled to. Martin, if I could bring you to clause 16, and it refers to the powers to require production of evidence.
Yes.
And you may recall we had raised the issue around the public records and the withholding of records.
Yeah.
Now, you've mentioned Article 8 a few times, and I'm not disrespecting that. But in terms of Article 13, I think it's 13, the right to an effective remedy, how are we going to ensure that those rights are protected if the public records aren't available to the inquiry or the people?
Yeah, I suppose, Carl, what I suppose clause 16 provides, as you say, is about us being able to, the inquiry being able to access them, but that is a slightly different conversation for an individual being able to access, and I suppose that's, Carl, something that the Preservation of Documents Act again placed a duty on institutions and bodies, including statutory bodies, to preserve it. An inquiry can then request it, but then the final step in that is about access, and I think there's been some good progress in terms of adoption practice guidance, but to be honest, Carl, there may be another legislative need there around what the panel have examined and have taken evidence around archival records and about access and improving access.
So sorry, Martin, I suspected this. Is there a possibility, or like, for example, would you be minded to bring forward even an amendment from the Executive Office to ensure, because it seems really unfair that for decades, and probably then some, for victims and survivors and then their living relatives who have tried to get access to their own family history and they can't.
Yeah.
And then an inquiry has immediate access and they may not be entitled to that. unless there's some sort of legislative base for that to happen.
Yeah.
So rather than waiting, I I would urge you, and I'm sure you are doing this because you have been very methodical and sensitive in your approach. But I would just appeal that rather than making people wait, even if you need to amend your own legislation, there's no shame in that.
Yeah.
Because we all want to see full disclosure to these people.
Yeah, no, I'm happy to take that away, Carla. And like that, it is something that we've been trying to establish if it is a separate piece of legislation on its own, or whether there's something that could be fitted into this bill. We've some thoughts around, so there's some of these records are private records at the minute, and about how you would actually make those public records. But I think the key issue is around access, which is the point that you made there. So,
Chair, my next question is in relation to Clause 17, in relation to privileged information. And it says that witnesses before the inquiry have the same privileges, which is grand. But it provides an exemption from producing evidence if this is incompatible with an assimilated obligation. Now, it also talks about allowing evidence to be withheld on the same grounds of public interest immunity. And this could apply in civil court proceedings here. I really don't understand that, honestly, and I'm worried, to be honest, because public immunity interest certificates have been applied to ensure, particularly in legacy, that families don't get information, and absolutely none of us want that to happen in any scenario throughout the passage of this legislation.
Yeah, I suppose, Carl, just to maybe the root of that, before maybe going into the implications of it, the root is that is a clause from the Inquiries Act, and it's very similar. I think these provisions are mainly used in sort of national security processes, but I suppose I take your point, is that really appropriate here, and is it really needed?
I honestly don't, I don't think it is. I understand you wanting to put belts and braces. But see, for me, it just screams giving someone cover who wants it. And I don't think it's really appropriate for that to happen here at all, honestly. And I'm not being pedantic. I just feel it's going to unpick and cause suspicion when there's no need for it.
Sure. Happy to take that away, Carl. So,
Sure, I'll just leave the rest of the redress if you're okay with that.
Okay, thank you, Carol.
Thank you.
Do you want to, on the inquiry?
Yeah, just one very brief question, and it's less to do with the powers of the bill and more to do with a question that might have been arisen in the sort of consultation you've had up to this. Were there any either semi-judicial or judicial powers used during that period of time from 1921 to whatever the last date is, to compel people to go to a home or mother and baby home or institution? In other words, are there court records of people being forced to go? And the second part of that is, have we any information or indeed any evidence of what happened to women who were pregnant or had had a baby and ended up in prison?
Both of those or all of those are relevant, Stuart. So you will have, particularly in Magdalen Laundries, lots of people would have been admitted, or not lots of people, some people would have been admitted who were under sort of court order. So that is a potential admission route into a laundry. We don't know how common that is, but we know there is that was a pattern. And then I suppose in terms of court orders more generally, particularly around the adoption system. So I think the adoption legislation, came in 1929, and went through a sort of care order or court order, and then an adoption order, and there's a whole series of steps. So there will be court records which are very relevant to the investigation, and there's been some work done with the court service, just identifying what records are held, and I think primarily for the inquiry, and that's, I think, something that would need a the powers in section 16 or clause 16 to use. So,
And that will compel the Department of Justice and the record holders to
it will
divulge
compel
all of those records.
court records.
And are we aware if were there any women who had their babies in prison and then subsequently had their babies removed?
I don't know whether that's
Sorry, I
right
don't
for
know.
now.
It's
It's an interesting
for now, but
question,
it's a
but
point.
I'm conscious of time, so I haven't
Apologies.
got the redress yet. Sinead, did you want to ask a question on the inquiry, or do you want to wait till the redress?
You're mute.
Sorry, I couldn't get unmuted there. The inquiry itself, just a couple of questions. Well, first of all, I kind of want to align my concerns about the compensation, particularly the contribution, particularly around the religious institutions. And again, I think it's really important for the victims and survivors to know that those institutions will be held financially to account. And I just want to put my thoughts on the record over that as well. But thank you to everybody that has contributed and has got us to this place. It was really welcome to get the bill laid before the Assembly on Monday and moving forward next week as well. I just want to ask a question around relevant persons. What kind of safeguards will be in place to ensure this exclusion power is not just used as a way or to prevent survivors or denies recognitions of those with lived experiences of institutional harm?
Yeah, I suppose, Sinead, just to reassure, I suppose we actually had quite a lot of debate about whether we should actually put this clause in or not, because you could have just been silent on it. But we thought it was actually important to, particularly in relation to workhouses, because there were so many experiences in a workhouse. So people that could have been in a workhouse for destitution or to work and or for care, medical services. So we wanted to identify the particular sort of experiences within a workhouse. So I think to reassure, this clause is more to define and to help shape the inquiry than to exclude. It's just there to try and say these are the experiences that we want to try and look at. And effectively in 4A, we're basically saying we're interested in anybody who was admitted and any children, now adults who were under the care of the institution and or left immediately before birth as well. So we've lots of experiences of an individual being in Marion Vale and then going down the road to Daisy Hill to give birth, and then that child, now adult, would have never been in an institution, but we still want to understand and for them to be part of the investigation. So.
And Martin, will any future exclusions or definition changes be subject to a meaningful consultation with the survivors, the survivor groups, in relation to that?
Yeah, I suppose relevant person.
Really, I'm really concerned about the transparency of all of this.
Yes, and I suppose, Sinead, I think there's two things there. One around, I think there's a separate discussion on redress, but just to reassure you that basically that clause around relevant persons is through regulation, so it goes through assembly processes as well, and there is that sort of transparency on the inquiry side. And I think we can talk about the redress, because I think that's a concern, obviously, on the redress side as well. So.
Then just another clarification regarding the appointment of the inquiry panel members. I'm going back and forth to find out what clause it is here. We see 5.2. But anyway, how will we ensure that these appointments are fair and transparent? What mechanisms are you using?
So I suppose there's probably two different processes. There's the in clause 5, the inquiry panel. Generally, these are sort of what be classified as sort of conversations with purpose. They are ministerial appointments, but we've asked for nominations from victim survivors in relation to that, and then also additional nominations from other sources as well. That will go through a shortlisting process, and then there'll be, I suppose, a short list of 2 or 3 individuals who will then, it'll be 4 ministers to determine the preferred candidate around that. And then I suppose, Sinead, on clause 10, which is the advisory panel, what we went, so just to give you the example of what we did for the independent panel, we went through a public appointments process. There, I suppose that as an option that's available, or whether there's another method or model that can be used. And I think a key element of the advisory panel would be about representation, that you've got that mix of experiences in an advisory panel. But I suppose ultimately that would be for a chair to decide, but that would be my sort of instinct.
And am I reading this right? Is, you know, there in clause 7, the First and Deputy First Minister has the ability to override potential conflicts of interest. Can you talk me through that one?
Yeah, so I suppose it's again similar to the 2005 Inquiries Act. The general principle is, and we've tried to outline there what direct interest or close association is, but in the event that, let's say you've got a very suitable candidate who's got lots of qualities and lots of experience and is the right person, but is conflicted for a reason, or there's a potential that it's declared, managed, assessed, and then there would be a decision about whether that was appropriate or not to appoint. So it's just, I suppose it's that conflict of interest, whether it's real, perceived, or actual, and that there's a process that at least can be considered, documented, and it would be then for ministers to decide if that, if the public interest effectively outweighed the conflict. So.
Right. Okay, that's fine. Thank you.
And maybe a broad question that before we move on to the next section, and that's in, so if we think that our committee stage will end in December, possibly January, go through royal assent, when do you think the inquiry will actually be established?
So I think we would like to be in a position to have an inquiry chair in like this. We're in the process of trying to shortlist, so we would like to be in a position to probably appoint over the summer or autumn time, subject to us. I think, to be honest, one of the biggest challenges we're going to face is actually about securing if we get the right person, then there's obviously logistic elements around that as well. So, but that would be our strong preference, is to have someone in a designate form in advance, and lots of practical and operational things that would need to be decided. So
you won't have to wait.
Exactly.
Basically. Okay.
Exactly. So.
Okay. We'll move on to the redress.
Okay, that's great. So I'll hand over to Elaine.
You.
It's probably about 5-10 minutes. I'm happy to cover the financial effects of the bill after Elaine speaks as well. So.
So the AFM covers 13 redress clauses, so we'll just talk through some of the key ones. So clause 30 establishes a redress service. Schedule 1 has more detail on the sort of structure and functions that the redress service will carry out, but generally similar to the arrangements for the Historical Institutional Abuse Redress Board and the Victims Payments Board, and that will be an independent body established to administer it. Clause 31 sets out the entitlement to a payment and includes the payment amount. So the standardised payment, as Martin has mentioned earlier, it's only based on admittance, so there's no requirement for an individual to provide any information on their experience in the institution. And as Martin said earlier too, that will come later in the second scheme that will be called the individually assessed payment scheme. But this legislation is only dealing with the standardised payment. So the later payment scheme will look at the experience of the individuals whilst in the relevant institutions. But for now, it's just purely based on admittance. So the basis of the standardised payment scheme is acknowledgement to those people affected by a system of institutions established for women and girls, where there was a gender specific and undeserved shame and stigma attached to that admittance. So for this reason, each individual will only get one £10,000 payment, even if they've been in more than one institution, because as I've said, their experience will be covered in the second payment scheme. So this scheme provides redress on a common basis to all individuals admitted to the named institutions and their children. So as we've covered some of the different experiences that could have resulted in people being admitted to the institution. So there's a wide range of experiences included. And Schedule 2 also enables the Executive Office to amend the list or change the relevant time period. So if we've talked about this earlier, but even if the time period isn't quite right and needs extended a bit, then there is the power there to do that. So This scheme is more inclusive than other comparable schemes and will inevitably incorporate a wide range of experiences, and both the mother and their child both get £10,000. The admittance of the mother is the child now adult's application is predicated on their mother's admission. So the child may never have actually been in the institution. The mother may have went to the hospital, for example, and the child now adult never came back to the institution, but they are included. So I think that was a slight concern of some of the victims and survivors, but I just want to be clear about that even if you went elsewhere to be born, then you're still covered by virtue of your mother's admission. So a payment does not impact benefits or take into account any other payments that you might have received in relation to this, for example, a previous civil claim, and it doesn't require a person to sign a waiver against taking any future civil claims. In relation to posthumous claims, Clause 31 sets out that an eligible family member making a posthumous claim on behalf of a deceased relative would receive £2,000, and there's further detail regarding how that amount was arrived at in the EFM, in the financial effects element of the EFM. This approach, Martin mentioned earlier, reduces the privacy concerns around the options that were previously put forward in the consultation, as each eligible person now has to make their own claim for posthumous rather than one application being made on behalf of everybody that might be entitled. The posthumous payment is based on what the deceased would have received had they been alive, and so it's not a bereavement payment, and it's not a payment to the relatives of the deceased based on the experience of the family member. It's purely what the deceased person would have received had they been alive. Eligible family members who can apply are the surviving spouse and partner and all surviving children, including any that were adopted into another family. In order for a posthumous claim to have been made, the deceased must have been alive on the 29th of September 2011, which is the date that the inquiry into historical institutional abuse was announced. So redress schemes usually use a date of state acknowledgement or announcement as their posthumous date, and this is particularly pertinent in this case because we're going back over 100 years. It is a sensitive and difficult area, and we appreciate that there's not a general consensus on what the date should be. The bill also allows for regulations to be laid so that an eligible person may be treated as not eligible. Now, really, this is an important safeguard. If other institutions get added on, just so that we are able to specify particular cohorts within an institution, so that maybe everybody isn't included, which would be taking people in that aren't within the spirit of the scheme. So we may never have to use that, but it is there as a safeguard if needed. Another key clause is the power to require further information or oral evidence. So that basically gives the judicial members of the service the power to compel evidence. So that could be from anyone who has information, and it's purely for the purposes of verification of the applicant's stay in a relevant institution. We can talk a bit more about that if you feel it's necessary, but there may be cases where the institution may not have the information for some reason or another, and the redress service will then take all reasonable steps to find out the information from elsewhere. The final key clause that I wanted to mention is clause 42, so that relates to the regulations that will follow this primary legislation. As you'll be aware, secondary legislation is required to set out the procedural aspects of the scheme, so things like what information is required when an application is made and things like that. So they will follow later on. So happy to take questions.
Okay, thank you very much. Okay, so in terms of so first of all, Martin, I've asked you twice, and I'm going to ask you a third time today. And I hope Hansard take a good note of this. I wanted from you the cost of the research that was commissioned from Queen's and UU, was published. Okay. I want the cost of the Truth Recovery Design Panel. I want the cost of the Truth Recovery Independent Panel, and I appreciate they haven't finished reporting. I'm not so much interested in the consultative forum, but I want to know how much we've spent getting to this point, because I think it is relevant
Yeah.
to the following questions.
Yeah.
If you have that now, great.
Okay, I'm happy to do that. So the original research by Queen's and UU, that was £206,000. The Truth Recovery Design Panel was £266,000. And then the independent panel obviously is not finished, but they've got a budget of £2 million, and of that they've spent approximately £1 million to date. So those are the three, and that is coming to you in written form as well. So apologies, it's taken a bit of time to get that, but we have that. So
Okay, thank you. I really appreciate that. Okay, so in that space, we're up to $100 million and a half.
Yeah.
Okay, we're up to $1.5 million. So the entitlement to a payment, clause 31(5)(b), pages 17, 18. So a person is eligible under this subsection if the deceased died on or after the 29th of September 2011. And Elaine, you had indicated there that you chose the date of HIA, which is a separate issue altogether. HIA themselves used the date of the 29th of April 1953. Now, I did contact the Commissioner's office today. She wasn't able to, she's on annual leave, wasn't able to get that. So why would there be such a difference then in terms of redress?
Yeah.
And I have a second point to this. Okay, I'll come on to this. So this is the payment, and then clause 31(9)(b). The payment is to be £2,000 if the person is eligible under subsection 5, which I've just indicated there, which is deceased. So in the Executive Office's Victims and Survivors of the Troubled strategy, you talk about intergenerational trauma.
Yes. Okay.
So you've acknowledged it for victims of the Troubles, but this £2,000 payment doesn't seem to acknowledge that the children, whether they were the adoptee or not, they will have lived with this intergenerational trauma. So £2,000 to recognise that is appalling and insulting. Okay? So please talk to me how you arrived at that date,
Yeah.
and also how you arrived at that 2,000.
Yeah.
Thank you.
I suppose, Chair, through the consultation that we looked and we tried to document some of the decisions, some of the key decisions was basically some redress schemes don't have any posthumous claims, so that was one decision that had to be made about whether you would accept posthumous claims or not. Now here in Northern Ireland we generally have posthumous schemes, so I think Stormont House is, or for Troubles payment, it's the Stormont House agreement. Judge Hart had recommended September 2011, and through a political process that was moved to 1953. That is a harm-based scheme. This is an admission-based scheme, so those are two quite different processes. I suppose as Elaine has outlined, this is about when an individual would have expected to receive redress. So it is based on expectation, and it isn't tied to a sort of liability or a bereavement or an intergenerational trauma payment. It isn't that. It is about an expectation of when the person would have received redress. So that's
Okay, but we know, because I was involved in the HIA, even though it was Westminster, was involved in the sort of political discussions around that, and we recognised that even being in one of these children's home institutions, they were subject to harsh conditions.
Yes.
And that was why so many of them were included in the umbrella of being eligible. And I'm saying to you, I can't understand why you're applying a different logic to this.
So I suppose I think a key distinction, particularly on the standardised payment, it is an admission-based scheme, and it is trying to say that people,
The standardised payment of HIA was as well.
well, I think HIA was generally, it is a harm-based scheme.
But I remember being involved. It's around the harshness of the environment.
That's right. But it was also required a sort of statement of experience process post a public inquiry as well.
Whereas this scheme is just purely on admittance, so it doesn't matter what your experience was. If you were admitted, you're entitled to this payment. Whereas with the HIA, you have to.
I honestly thought the standardised payment was just because you were in that harsh environment.
I think there's there is a fixed element in HIA, but I think it is based on a statement of experience. I would have to double check.
Okay, please double check that.
Please.
But this date of 2011. I mean, I think a lot of people have been very upset by it. They saw their mothers living through the trauma of having to have their child taken away from them, and I just think that it's quite insulting.
Yeah, and look, I think we've received that feedback as well, Chair, and I think I suppose what we've tried to balance is some of those aspects around the redress scheme. I think there is a separate scheme to come around the individually assessed. This redress scheme, I suppose, about 45 million of it is trying to go out directly to either a person who was admitted or a person, a child now adult, who was in or linked to their mother's admission, and there's about 13 million in terms of posthumous payments. So it's trying to get a balance there between that mix and making sure that in terms of the IAP scheme as well, that there's enough flexibility there that we can make sure we can provide appropriate redress to all of the cohorts there. So that's partly the sort of the balance we've had to make here as well.
Yeah, but I think it's grossly unfair, because obviously there will be a huge taper off in terms of people who will have the memory, will be aware of their mother. So I think it's quite an arbitrary cut-off point, and I don't think it's actually necessary in the spirit in which this whole process of looking into what happened to these birth mothers and their children. So I will leave it there, and I think as a committee we will come back to this time and time again. So the £10,000 standardised payment, so you'll be aware that the birth mothers, etc., are saying that this should be inflation linked. So the Westminster legislation was 2019, and if you take £10,000 in today's money, and we haven't got the redress, so we can't project, so it would be the equivalent of 12,771. But if you took it at 2020, when the redress scheme opened, £10,000 in today's money would be approximately 12,500. So I've heard the arguments from within TO around, that would be unfair to people who received under HIA, but I think it's unfair on the birth mothers and the adoptee adults that they're being asked to accept, in real terms, a smaller amount of acknowledgement money.
Yeah, and I understand that argument as well. I suppose to outline the HIA scheme just closed there. So I mean that £10,000 was available there for people from April of this year. We've looked at the two international examples if we've got around sort of birth mother experiences. One was the Republic of Ireland scheme, which basically it's difficult to get an exact pattern, but basically a birth mother, the minimum payment was around €5,000 for a sort of 3 months in an institution. I think I'll double check that that's exactly right, but they also excluded anybody or any child, now adult, who was in an institution. They had to be in for at least 6 months. So this scheme tries to address that. It's including a lot of individuals who have been excluded in other processes. And similarly, in terms of the forced adoption scheme in Australia, in Victoria, they provided a $30,000, which is about 15 or 14,000 for a birth mother experience. But they didn't compensate, or they didn't provide, compensate is not the right word, payments to any sort of adopted or adopted adults. So I think we've tried to balance those, and I do take the point around the inflation elements, but I think it was just, again, about trying to, this redress scheme in lots of ways is about trying to get lots of people a bit of money. This is not compensation, it is just trying to get as many people as we can some money. So.
Okay, last one for me, and it's coming back to this high levels of infant mortality and the Queen's UU research, as you know, you outlined it very succinctly, and they did say it was difficult because they didn't have all the records. But I'm just wondering, in terms of redress, how is that going to be factored in? Is it going to be in the individually assessed payments where mothers maybe had a very undignified pregnancy that's resulted in a stillbirth, for example? But how is that going to be reflected? Yeah,
I suppose, Chair, this is probably one of the most difficult aspects, and we heard directly from people during the consultation process around that. The standardised payment, I think the short answer is that experience of child loss at birth would be covered and captured in the individually assessed payments. So it sort of feels like the most appropriate place for that to happen. So.
Okay, thank you. That's for me. Go ahead, Deputy Chair.
Yes, just slightly, the Chair, I think, has very clearly outlined our concerns about both the compensation and the £2,000 payment. When you come to the £2,000 payment, I appreciate you have to have a date. And I suppose in the extreme, you could actually cover all the way back, as she says, it tapers. You could cover all the way back to the creation of the Northern Ireland state. But what about the 28th of September? What about the 27th of September? How satisfied are we somebody's not going to fall literally within a minute of the wrong side of that line? And birth certificates will be to the minute, so that's potentially a very distressing point for people. And have you, and this shouldn't be about pounds and pence, but have you costed out a range of scenarios in respect of these payments?
Yeah, we have, and that's something that we'd be happy to come back and provide to the committee in relation to that. It's just to provide sort of that, I suppose, Stuart, there's lots and lots of different scenarios in this, so it isn't like a very straightforward question to answer.
No, and that's why I'm not asking you to put a figure on it now, but it would be helpful to understand your thinking. And I'm going to say this to ensure that we are satisfied that money is not the issue that you're determining this on, but I think we need to see what your working out of that was for us coming forward. One other area of the bill in clause 21, I suppose it's not redress, but it is the expenses for witnesses, just to be satisfied that is effectively a standard payment, or how will that be assessed for each? And presumably there'll be travel to and from the inquiry for witnesses, but I'm just interested to know what that payment will actually be and what it's based on.
I think primarily 21 would be around sort of travel and subsistence type activities for individuals to provide evidence, oral evidence.
But at what rate? I mean, have you determined what that rate would be?
I actually don't know.
In regulations, that's something.
Is that in regs? Sorry,
they're covered in the regulations.
It's
That'll
covered in
come
the
in front of
regulations. But
yourselves
I take
after.
it covers presumably some sort of standardised formula that's used.
Yeah, there would be a standard formula, and it would cover the expenses of lots of time, travel, legal costs, other different things. But they're set out in regulations rather than in the bill.
And just one other issue that's in regulations, Chair, and that's a list at Schedule 2 of the relevant institutions. Are we satisfied that that is the exhaustive list? And if not, is there room to add somebody else should they appear?
Yeah, so we're not satisfied that it's an exhaustive list, and that's why we've got part 2 of that schedule, which basically provides power to amend that list. And so there's, by regulation, we can add or remove an institution, and then we can also amend the years as well. So we're not satisfied
if you're not.
So, but there is a process. We're not satisfied that it's a complete list, but we are satisfied there is a process to add. So yeah.
Thank you very much.
Brian, please.
Okay, thank you, Chair. Part 2, page 17 of the bill, it says the Truth Recovery Redress Service is established. Is that the case? Or what? Will it be established within TEO? Will it be a civil service-led service? And does it exist now, or is this basically saying it will exist?
The legislation establishes it, but and similar to the other schemes that we've mentioned, it will be another civil service department that will be designated to administer the scheme, so carry out the administrative functions, but it will be an independent body. So the Department of Justice administers the Victims Payments Board and the HIA Redress Board, and they have been doing preparatory work for us for the last number of months in terms of what the board would look like, and policies and procedures and operational arrangements such as amount of staff, IT system, things like that, so that we're not having to do all that at the back end of this, so to get it all done in advance. So there will be a need to have a formal designation then once the legislation's in place.
Right. And are you saying it has been decided it'll sit within DOJ, or that's
It
yet to
can't
be decided?
formally be designated until the legislation's passed, but the Justice Minister has engaged with the First and Deputy First Minister in relation to this, and there's an agreement around sort of up to the point of legislation, and that's been very welcomed because it means lots of the operational staff, infrastructure, skills that would be required for a redress service are available and can work on this, so that we're not having to pass the legislation and then think what next. So that's been very welcome. So.
Okay. And what is the expected timescale when the bill passes? What's the process likely to be? I mean, people will have to apply. We don't have a list currently then of people, or
no, it'll go out to, we don't have,
and people will ultimately have to apply.
Exactly, that's exactly right. So it is an applicant based, so that people have to apply for it. Now, the process, I suppose, primary legislation, as I think it's 42, is the regs. So we would hope to consult on the regs prior to royal assent. So that sort of is our hope. It's slightly risky, but I think in the process that we've got here, we would like to think that that's appropriate, and then that, I suppose, we'll go through that this committee as well around the regs. But so I can't give you, Brian, a definitive, but I think it's just basically we would like to do the secondary legislation in parallel to the primary actually receiving royal assent. So.
Right. Okay, but obviously, given the age of some of these people, timescale is very important.
Absolutely.
You know, and given that the amount awarded won't be inherited, as we've heard, you know, the 10,000 becomes 2,000. So, I'm going to push you. Give us an idea, a ballpark figure. Come on, I mean, within a year, what do we think? It'll be active and making payments. Well, within. Obviously, the bill has to pass.
Exactly. I suppose, Brian, the key thing is the primary, the bill passing that sort of sets the timetable then for secondary. But you know, you would want to be making payments next year. So
right. Okay. You'd be expecting payments to go out 2027. 2026. Apologies. Yes. Okay. And just one point in Schedule 3. Paragraph 3. Let me see, find it myself. On page 30 of the bill. Yeah. Maybe it's to cover some eventuality, but I don't understand the purpose of number 3 there. The reference in paragraph 1b to a child of the deceased includes a child of the deceased who's been adopted by another person. Yeah. I mean, I don't understand why that's necessary to say.
So, do you want to?
I guess it's a legal thing, and an adopted child is no longer the child of the birth mother. Yes. So, it's to ensure that the adopted child is also included.
Okay,
so
it's just a fail-safe to make sure
that
somebody doesn't lose out.
Yeah. Exactly.
Okay, I'd have thought it's obvious, but legally, whatever. That's okay. Okay, thank you, Chair.
Okay, thank you. Timothy, please.
Yeah, a couple of quick ones. Going back to the standardised payment of £10,000. Obviously, it's a recognition payment of somebody that has been in or connected to. That doesn't prevent anybody taking a civil case. The second scheme, will that be different?
So, don't know, but you would presume, Timothy, that if you were taking if you accepted the individually assessed, it would be a very common feature of a state redress scheme that you would.
For the 10,000, that doesn't apply.
For the 10,000, we just want to keep it simple, try and get some money out.
31(5)(a), so talking about the eligible relative, just for clarity. So, if there were 6 eligible relatives and it's £2,000, will come to £12,000, but you're saying that there's a cap of 10, is that correct?
No, there's no cap. So if there was 6 eligible relatives, so let's say, for example,
£2,000 each regardless.
Exactly. So we've tried to, in the EFM, we've tried to outline a little bit of that's not that scientific, but we've tried to look at something called a total fertility rate. So what is the average family size? So we think it's in the period it was probably in around 3 children. Then if we've got a spouse or partner, and then we've got a child that was separated at birth. So we think there's maybe on average you've got five potential people.
Is that how you arrived at the £2,000 then?
That's how we arrived, and then we've applied, Timothy, a little bit, and this is sort of getting maybe quite technical, so I apologise, but as we've applied a little bit of, we've looked at posthumous claims generally are lower, people are less likely to claim for posthumous, so we've applied a bit of it, what modelers would call a deflator. So your propensity is lower for a posthumous claim just generally. So that's why we've got a slightly lower cost on posthumous. You could have 2,000 claims, but you might only have about 3 actual applicants. So maybe I think it's maybe something I should put in a paper, because it's quite a technical. But in theory, there's no cap. It's not capped at 10,000. It's if you have 10 eligible relatives, it will be £2,000 each. So
32 1A and moving on to 2. So time limit for applications for payment. So before the end of the period, 3 years beginning with the date, and then you go down to number 2. That can be extended to 5 years. Going by my short time instalment with the HIA, once it gets to the final period, there's always a rush and there's more publicity and more people are talking about it. Does there need to be a maximum of 5 years in there?
I think that's your point, Chair, as well. So I suppose the reason why is in part it's actually probably quite an expensive way to keep a scheme open and have judicial members there, and I think time bound it provides an opportunity and try to encourage people to apply, and I suppose that's partly a behavioural thing, that if there is a deadline people are more likely to apply to that process, so there's balances there, and that's probably something.
By putting 5 years, that's closed door. Once the legislation's through, that is the final.
I suppose that if there's an individually assessed payment coming on the other side, a mechanism might be there that you could also administer. So someone who had missed out on the standardised payment could maybe also apply. There could be a mechanism there under that scheme as well.
The criteria for the second payment won't be applying for the standardised payment?
So no, the criteria for the second payment is generally, if you look at other harm-based schemes, it's generally factored on 3 key areas. It's duration, severity and impact. And there's lots of different models you could use, but you could invite people to basically, it's very much about an individualised experience. So one of the challenges we faced on this is about some of the institutions that we don't actually have enough information on some of the institutions, but they would be better catered for the individually assessed, where you can look at those individual cases and say, well, that was the same or similar to someone who was in a mother and baby institution. So
thanks very much.
All right, that's just occurred to me. So, see the individualised payment, or sorry, the standardised payment. So that's basically somebody saying, yes, thank you, I'll take the 10,000, whatever, fine.
Or 2.
So, that means that they have sort of excluded themselves then from going through the individualised, or they can do it. That's okay.
Yeah, the individually assessed is an addition. So
okay, because it was
sorry,
conscious of something. No, it's probably clear, but it's just there's that much other stuff going on. Go ahead. Yeah.
Okay, if I could just come back in, just remind me, the estimated cost of the scheme is around 80 million, I think. Is that the right figure?
It's 80 million for the bill as introduced, and that breaks down as 58 million on initial redress payments. We've applied a bit of a range in the EFM because this is a demand-led scheme. I mean, I sort of provide this sort of we don't know how much it's going to cost. It is very much driven on demand-led, and there is limited means of control, Brian, as well. So it's 58 million initial redress payments, and then 40 million on the inquiry, which again is very driven by the work that we're going to and the recommendations we received from the panel. And then there's about 8 million on the redress administration. So that's what the costs build up to 80 million. So.
Right, and at this stage, it's not clear whether there'll be an element from Westminster towards this. It might come out of the Northern Ireland Block Grant.
It's at the minute it will all be funded from the Northern Ireland Block Grant, but
Right,
then
it will.
with the
That's it.
view that obviously contributions and contributions from Treasury, there has been engagement with Treasury and the NIO on it. They haven't got very far, or as far as we would like. That's probably how I would describe it. So,
Okay. And in this bill, the engagement with the institutions to get them to compensate to the Northern Ireland public purse, because the public purse is going to be paying this money out in anticipation of getting that money back. Is that in the bill? I don't see it then.
so there's
When is that process underway, or when is it starting, or where's the legislation for that?
So, I suppose, Brian, most redress schemes are on a voluntary basis, so there wouldn't be a legislative footing for contributions. There's Scottish Redress have an obligation to report on that, so that's maybe slightly separate sort of statutory footing. The Republic of Ireland are examining and have examined. There was a negotiator, a woman called Sheila Noonan, who negotiated with 9 of the institutions in the south, and I think disappointingly only 1 of those made a meaningful contribution. And that process concluded there in April. So they're considering what options they have available as well. So
did you say there's no actual legislation involved in that?
not, and we haven't been able to find.
Is that the case in HIA?
That's the case in HIA. So it went through a negotiation, a mediation, and then an arbitration process. So it's sort of a quasi-judicial process. So.
Okay. Well, I'm sure we'll get an update on that in due course. Yeah. Okay.
Okay. Thank you, Carol. Please.
Thank you. Can you hear me?
Yes. Thank you.
Okay, so some of the questions I was going to ask have been asked. So given that this is a voluntary scheme in the same way that HIA was, will the arbitration, the negotiation be completed by the time the inquiry starts? I think it's important that it is, and the position of the institutions is reflected as part of the public inquiry, and that may need to be stated, even if it's not in legislation, but certainly in intention, because you know what the issues are. And then the other question that I wanted some further explanation on, if at all possible, is the role of the British government in the NIO, given these institutions predate devolution. You know, where is the discussions? I know you said they haven't went as far as you're content with, Martin, but you know, is there no acceptance that there's going to have to be something provided to this redress scheme at all?
So, Cara, I think just this has been, my understanding has been raised by the Finance Minister or the Chief Secretary to the Treasury, and it's also been raised by First Minister and Deputy First Minister with the Secretary of State. I think there's been requests made around engagement. The core argument there is that lots of these institutions operate after 73, and a lot of the experiences we've are actually looking at will be in that period from 73 to in the 70s and 80s. So there is a sort of moral argument and a legal argument around that, and there is a sort of a policy element to that as well. So there was legislative changes in UK and England and Wales that weren't reflected here for a period. So there was a 10-year period of difference. So I think that's the sort of the moral and sort of policy argument for that, but there hasn't been as much movement, Carol, to be honest, as we would have liked to have seen on that, or as ministers would have liked to have seen on it. But I think there's discussions ongoing on that. So So that's the sort of the second point, and then the first point around voluntary. I think the key aspect, and Francesca's outlined, this is an independent investigation. It's designed to establish what happened, why did it happen, and who was responsible. And I suppose that sort of responsibility will be a key part of the inquiry to determine some, to be honest, the level of responsibility and the share of responsibility between state and other actors. So that's sort of an assurance we can provide around that. So.
But this is happening under the 2005 Inquiries Act, okay? And even in part 10 of the EFM, it outlined what you just said, what happened, why it happened,
Yes.
and who was responsible. I think even, you know, the references to HIA and the rest, I do think it's important that even an up-to-date statement on voluntary contributions from the orders and institutions needs to be part of this, because it's also part, very, very clearly part of acknowledgement. Part of the acknowledgement, not the acknowledgement, for survivors and the victims of these institutions. And have you even considered that, Martin?
I suppose we've had some engagement with institutions primarily on the investigation in terms of records. There has been, I suppose, discussions around the intention around redress and around contributions. There's a formal, probably a more formal process that will enter into. I think for this bill, and I think we spoke previously about this, about whether we could actually fit a provision into this bill. We didn't. There isn't a provision in here at the minute, but that is maybe something as we go through the committee stage and as we get closer to sort of the end of this process, that might be something that we could work with the committee with as well. If that's...
I think it's important because every member in our committee, regardless of political party, whatever, has felt the unfairness, for want of a better term, and are really frustrated at the lack of development from these orders and institutions on behalf of the victims and survivors. And I think it would be remiss of us as committee members not to, I mean, what we're going to say is, if there's nothing that can be put in as part of the bill, then it's going to be left out there. And I don't want any of the good work that yourselves, along with many, many others, have done just to kind of leave that part to the inquiry. I think it's important that we try and find a way that happens. Because redress, that we're talking about financial aspect of it, but we're also talking about the actual public, part of the public acknowledgement of this as well.
Yeah.
Thank you, Chair.
Thank you. I just have a quick query. So the redress scheme, will that be open to mothers who gave birth in the south but their children were adopted in the north?
So it depends on the scenario. So,
Okay.
but the chair, it wouldn't be, the person would have to have been admitted into one of the institutions listed.
Okay, so just clarifying, right.
That's the short answer. If that's the scenario, there is
Okay.
is no. It wouldn't be, but every case is slightly different. So, but the principle would be they would have to be admitted within
An institution in Northern Ireland.
within an institution in Northern Ireland. And saying that, cross-border transfers and movements is a key aspect that the investigation would like to examine and look at. So.
Okay. Okay. I think, Sinead, are you looking to say anything? Yes. Go ahead, please, Sinead.
Sorry, I'm having problems getting my mic on. Can you hear me okay?
Thank you.
Okay, yeah, really, just talking about the affordability and transparency based around clauses 31 to 33. Can you confirm whether the affordability concerns shape the flat rate in clause 319? and why wasn't survivor engagement not considered when you and talk to the survivors? Why was it not considered, a tiered assessment and needs-based payment?
Right, what was the last bit there, Sinead? I just missed. I just broke up there. A tiered payment, and then was there something else?
And like more or less a needs-based payment model as opposed to the flat rate, based on the severity and the experiences of the actual survivors themselves. And just, was it the affordability concerns that were taken into consideration around that?
So I suppose to answer the second part first, so the or the first part, basically the needs based in terms of that will be factored into the individually assessed. So that will be based on duration, severity, and impact. So that, Sinead, is designed to, I suppose, replicate in lots of ways what HIA provided for, which was a range between 10,000 and 80,000. So that's based on an individual's experience. What the standardised payment, we've looked at international examples, and we've looked at sort of comparators to determine what would be a suitable or a sort of commensurate level of award in comparison to other schemes. And I suppose in all of these decisions, there has to be a consideration around, I suppose, that the balance of where resources should be, whether both in the SP and the IAP, but more generally as well. This is a big scheme, and there has to be a balance there to make sure that there's resources to cover the individually assessed to come as well. So.
Okay, has there been a fiscal impact assessment made on the model as it's currently in the bill here?
So do you mean so we've outlined, I suppose, the 80 million in the bill. Are you
but the impact assessment in terms of if you carried it out, obviously, you say you don't know the numbers as yet, but have you modelled it all out?
Yes, yeah, we've looked at sort of I suppose other comparator schemes. We've looked at lots of factors like propensity, so how likely is it that individuals. So one of the interesting things is you could have a redress scheme that opens for 20 years and some people will never ever apply, and that's sort of just not so there's factors like that, Sinead, that we've factored in, and that's analysis that we're happy to share with the committee. It'll be important, I suppose, as you go through the scrutiny process, that's available and you can look at some of those elements.
Yeah, so I think that's really important because it would be just in the interest of transparency that we understand how that was modelled out to begin with. And then just like to future proof and review, is there flexibility built in so that you can have like a midterm review in terms of those that are coming forward, and perhaps even reviewing that flat rate if it is found that there maybe a reduced number of applicants coming forward?
There's nothing in the bill at the minute, Sinead, that has a legislative duty to do that, but that's something that if committee members felt was useful, that might be something that would be a good addition to the bill as well. So.
I think, to put in something like a midterm review in order to evaluate how the scheme is progressing, if that was actually stated in the bill, it would be very, very helpful. It would give us another opportunity to make sure that those that should be supported are being supported, and would help us just to evaluate the scheme.
Okay, not seen any other indications, so thank you very much for your work on this and for such a long session. I think you'd indicated there, Martin, possibly setting something out in terms of
queries. Is this? Yeah, there were some queries the last day around the financial costs, which would provide. There was a query that Carol had around sort of landowner consent, if you didn't have that for geophysical, and there was a query Brian had just around the list of institutions. So there's better correspondence that will come to yourselves and that. So.
Was there not something as well around the posthumous in terms of the thinking around that as well?
It's the modelling.
The modelling,
we're happy to provide. It's quite detailed, so I suppose there's maybe, I don't know if that's a separate session, but we're happy to send it, and then if you can have a look and see what you think. So.
Well, some of that be useful before summer recess, so then we will have time to sort of digest it before we come back for the evidence session. So if we can get some of it sooner rather than later, we'd appreciate it.
Our best.
Okay, thank you very much.
Thanks very much.
Okay, members, before we go into our next session, I just want to take a 5-minute comfort break now, and then,
Yeah, thank you.
Okay, thank you. Thanks very much.
Committee Room 30. Sound. 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 Committee Room 30, 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 Sound.
Okay, members will go back into open session. So we're moving on to our next oral briefing, and that will be the Commissioner for Older People for Northern Ireland. Okay, members, so if you go to pages 38, 39 of your pack, you'll find the clerk's brief, and you'll find a written briefing paper from the Commissioner on pages 40 to 63. So you're very welcome, Siobhan. Siobhan Casey is now our new Commissioner for Older People, and Evelyn Howe, welcome back to committee, who is the Chief Executive at that Commission. So thank you for your very thorough paper, really appreciated getting it in advance. So just wondered, do you want to make some opening remarks, please?
Yes. Good afternoon, everybody, and thanks for giving us the opportunity to come and chat to you today. My Siobhan Casey, I am the new Commissioner, but previously I worked with AGNI for 15 years, so I'm very conversant with the challenges, opportunities and contribution that older people make to all of our lives. I've looked on at company for a long time, and I've really honoured to have got the position and take forward the work of the previous commissioners that have, you know, some of the things we'll talk about today that they have contributed to. I think it's, you know, thanks to the foresight of older people who lobbied to get this role, but also the responsiveness from government to actually have this position in place and really sort of enact the legislation to protect and safeguard the rights of older people. There's only been 2 commissioners in the UK at the minute, but we know that England are lobbying very hard to appoint a commissioner, and there's also in the Republic of Ireland as well. They're trying to do the same. So I think the Northern Ireland Assembly and the government here has taken the lead, and I think has the opportunity to be very progressive in terms of the work of planning for an aging society. So it's a real testament to the values of our government here, that, you know, it values our older citizens and what will be the fastest growing population in the UK for older people. So I'm week 10 in the job, and my next 4 years, you know, I've given you a bit of an insight in the brief as to what will I be working on. And I'm really, I have to say that, you know, we know, and I mean, it's big thanks to Claire Sugden in terms of the work that she's brought forward, you know, in terms of the work on GFS, but also in terms of the strategic planning for an ageing society. And I know I went through quite a detailed look at the last meeting of the business committee, and you know, the contribution of some of the people here in terms of agreeing that we should have a strategic plan for our ageing society. And it's probably fair to say that you know, we're all part of this progressive approach. However, probably equally disappointed at the fact that older people are not a priority in the programme for government at this time. But as you know, part of my work it will be over the next 4 years to support the team here to do that, and work collaboratively on that. So, you know, together with central and local government, it's our job to support older people, to underpin their rights and provide services and enact the laws, so we can eliminate discrimination and challenge ageist stereotypes. So the brief has been set out, you know, and I think the rationale in terms of an ageing society is very clear, and I know you've been all over it yourselves in terms of previous work. The quote that I always love is like, we are in a situation without parallel in the history of humanity. You know, we are our society is getting older, but certainly living longer, but maybe not living better. So the challenge is there for us all to be able to support people to live longer. I know, Ms. Bradshaw, you talked about the 50-40, you know, 40 years after 50 that we can live a healthy lives. So the big challenge that I was involved in with the UK government was the Grand Challenge in Ageing, and that's adding 5 more healthy years to life. So I'm hoping to bring that into my work as well. So we all know that we need to plan, and we have to lay the groundwork for older people today and tomorrow, and it's all of us here who will benefit from that, and our children as well. And I do, as I said earlier, think that, you know, we know the issues, we know what's happening in terms of, you know, GPs, access to GPs, access to services, access to transport. It's been, and the loneliness and isolation and poverty and deprivation that older people are facing. And we know the impact of, you know, the cuts that have happened, like the equality impact assessments from both the Department of Health and the Department of Finance are saying that this is a detrimental impact on our older people in terms of, you know, the services that they're going to get. So we know what we're facing here in terms of the challenges. So in the brief that I've given you, I've outlined my proposed priorities. My team and I have carried out a range of events and meetings over the last 10 weeks. We've we will by the end of 3 months have met over 300 people, and delighted to say that there's over 1,000 people have got involved in the survey, which is to help plan my priorities for the next 4 years. So there's been great engagement, which has been really good, and we're, you know, that I've given you an outline of the proposed priorities, but we will also take very much into account the voices of older people and what it is that they're actually saying to us. So to identify the gaps and any failures that affect us. So I want to continue to provide the high quality advocacy and support that we do. We provide to people who are experiencing difficulties with public authorities. I want to scrutinise the development of new and existing policies and practices, but I'm also future focused. So I hope you'll see that in the outline of the priorities in terms of, you know, as well as addressing the challenges and the issues affecting older people, that we're also looking at things like technology enabled care, like how we can support older workers, how we can bring in the support their prevention agenda. So I'd be delighted to hear your views today on what we've presented, and I would be delighted also if you would circulate our survey out to your constituents, just so that we can get more people to give us their feedback. And thank you for the opportunity.
Well, thank you very much. I suppose we've asked you to come here today, and we're delighted to see your appointment. A lot of the priorities under it would probably sit with another committee for scrutiny, for example, but I think the week that's in it, I would ask for your opinion on what was included in the anti-poverty strategy and how that reads across into some of your priorities there around cost of living. We heard a lot of voices earlier in the week from children's charities, and I just think it'd be a good opportunity for you to sort of reflect on the anti-poverty strategy from this week.
I think, we know the impact of poverty on older people, and it's probably the highest in across the UK and Northern Ireland. So I think that, the anti-poverty strategy is really kind of pivotal to addressing those challenges. I'm just wondering, Evelyn, if you'd like to.
Yeah, I think that's true, and I think that the characteristics of older people in Northern Ireland are somewhat different maybe from the rest of the UK, in that here we don't have maybe some of the wealth base that we would have in other parts of the UK. We do have significant numbers of older people who are having to make very tough choices, and we saw that with the backlash about the winter fuel payment last year, and we were delighted that that was turned around, and I think they've taken a very sensible approach, that it's not going to be universal any longer. I don't think that could be sustained, but I think that those who really need it are going to receive it, and we welcome that wholeheartedly. But poverty sits really right across the whole of the work of the Commissioner, and for us it's about the multiple identity of older people, because you can be older and poorer, and have difficulties with specific services, and have, so we tend, when we're dealing with older people, to take them in their totality. And you'll have heard me saying before, but I'm sure, but not a homogenous group, because older people are every bit as diverse as every other part of the population, just chronologically older.
Okay. Thank you. I suppose the other question I wanted to cover was in terms of that sort of, when I read your paper, the sort of broad range of areas you'll be looking at, and I'm conscious that we have an Equality Commissioner here. We've got the NIPSO, the Ombudsman, we've got the Mental Health Champion, and I'm just wondering how you'll work with them or find your own swim lanes in terms of the work, so that for maximum impact.
I think you're entirely right in terms of finding our own swim lanes, but for example, with the GFS legislation that's coming forward at the minute, which we're delighted about, we're working very closely with the Equality Commissioner and the Children's Commissioner, so that we can work together to see what the combined kind of approach will be. So, and the Mental Health Champion, we've got their meetings lined up with her and some of the other ombudsmen as well. So it's early days, but I think it's really important that we don't duplicate, but we're very cognizant of what each other's doing, and work collectively together where we can.
Okay.
You might want to mention the work we're doing with the Equality Commission on HGFS.
Yeah, that's what I was saying. We met with, we are working with the Equality Commission and the Children's Commissioner on the GFS legislation, which Claire's bringing forward. So, it's been a great introduction to the work that they do, and very delighted to do that.
I suppose the last one for me, and it was that you raised, I have that ingrained in my head, the sort of 50 good years and then 40. And I'm just wondering, just to pick up on your point there, Evelyn, around the sort of the loneliness piece, and the fact if you're out and you're physically active, etc. But older people are not a homogenous group, because there may be some people who love going down the local community centre or leisure centre, but there are a lot of people who maybe don't have those networks. And I'm just wondering if you have any fresh thinking about how we can get people up and out and engaged in their community for...
Well, see, what you'll see coming forward now is a report from us on sort of the age sector and the active ageing strategy, and I think that's going to be pivotal in terms of, you know, really working very closely. I know the health minister's actually said that himself in terms of working very closely with age sector and older people's organisations out there to expand some of the really good practice that is already here in Northern Ireland. But I think the active ageing and movement towards an age-friendly, more progressive age-friendly strategy will be really important. I mean, we've heard that the Minister for Communities is going to roll over the active ageing strategy. We're a bit concerned about that because we haven't got any. It hasn't been published what the consultation response has been, and there's been a lot of consultation on that. So we'll be working with them on that and working very closely towards building, better kind of resonance between active ageing and age friendly and prevention, as well. So, yeah, we'll be working on that over the next 4 years.
Okay, thank you. Deputy Chair, please.
Thank you, Chair, and thank you, Commissioner. You're very welcome to the committee. It's great to meet and listen to what you've been saying, and somebody who's used up some of those 40 years after 50. I have a very special interest in all of this. You've set out 10 priorities, and I welcome each and every one of them, and I could ask you for the rest of the day questions about those 10 priorities. But I have a very urgent and emerging priority in my constituency. That is that a nursing home was declared to be closed yesterday. The proprietors no longer are continuing that business. The residents in their home, and it's a nursing home, but it's their home and has been their home for many of them for quite a number of years, have now 16 days to move. That, I think, is totally unreasonable, that some 37 plus people are being asked to move. There is not space in Carrickfergus for 37 people in other nursing home facilities. Their lives are being turned upside down as of yesterday. Do you think that 16 days is reasonable for the Trust to be able to find alternative accommodation for those people and for their families? And what action do you think that Trust should take in terms of health and social care reform as one of your priorities? And indeed, just quite simply, in terms of the whole protection of older people at this very vulnerable stage in their lives.
I'm going to pass this to Evelyn, but absolutely not. That is not enough time, and the whole adult protection bill is really critical here. But I'm going to pass this to Evelyn.
Yeah, we were informed yesterday too about the closure of the home, and I understand that the provider in this case is closing because it's not financially viable. So we have had a range of issues around that. Yes. There's a few things that I think the committee can usefully know about it. One is that 98% of homes in Northern Ireland are provided through the private sector, and that's across profit, non-profit, charity, faith groups, the whole gamut. But what that does is it doesn't allow any provision in the statutory sector for when something falls over. And that is why we are seeing this happen. We've had the experience of a number of care homes, wanting to close at a particular point in time, and I can assure you, although I don't work for the Trust, but I can assure you that our position will be that the Trust will stick with those individuals until they have been found an alternative placement. That is what we've always advocated for. We've also advocated for people to be moved with kinship groups, within their sort of faith community. Those sorts of relationships are really, really important. And sadly, we see this happening, and there's always this sense of there isn't any place for these people. But I'll tell you now, I've never seen anybody come out of a care home who didn't get another place that wasn't satisfactory. And our efforts in relation to that will be to advocate on behalf of every individual client of that provider to make sure the duty of care does not pass to the provider. It resides with the Trust. And when you go into a care home, the duty of care for you resides with the Trust, and they take that very seriously. Now, we work hand in glove with the Northern Trust. As you know, the Northern Trust has the greatest number of older people in Northern Ireland. Consequently, we have a lot of engagement with them. And they've already been in touch with us, and we've already been in touch with them to talk about this. The Commissioner can't stop a home from closing, but I think it's extremely important that when something like this can't be prevented, that then the transition is done in the right way. And we have seen some very successful transitions in the past. So what I would say to those individual residents and their families is that if they're having any difficulty, to get in touch with the Commissioner's office. We will advocate on their behalf, independently of the trust and independently of the provider. So that is what we're there for, and we're very happy to do that.
Finally, Chair, and thank you for this. And I appreciate that assurance, and I'm sure that families and those people that are in this particular home will be assured by that. But what research have you done, given the very high percentage of private sector nursing and care home facilities across Northern Ireland? What research have you done to ensure that there is a robustness in the system, and that when a home comes to the point of failure or financial failure or inability to continue for whatever reasons, that that there is sufficient capacity in the system to ensure the best outcome for residents?
I think if you look back at the work of previous commissioners and right up to Siobhan's term of office, we have published a lot of information to the Department of Health. We've made recommendations coming from the Home Truths report about the risks of having so much provision in a private sector. We're told that it's not financially viable to have an alternative provision in the statutory sector. That depends very much on the minister at the time. As ministers have changed over the years, some have said we should look at that, some have said no, we're not going to. The most recent piece of research that we've done on care homes has been in relation to the human rights of older people in care homes and the contract, the regional contract. So the regional contract is under review at the moment, and we felt that the review was quite narrow in its focus because they were looking really at cost. And we were very concerned that we were hearing about lots of individual older people who were being evicted from their care homes through no fault of their own, because perhaps there was a relationship breakdown between the provider and the family, or between the resident and the provider. And so we have acted to advise the Health Minister about that recently. But the Commissioner can only advise. That is our, the willingness to take on that advice is with the Health Minister. And I don't believe that any Health Minister in the last 10 years could say that they were not aware of that issue.
I think probably.
Do you think there's a legislative shortfall here in terms of the ability for the department to actually have to act differently? For example, is 16 days too short?
The 16-day threshold, I'm not sure where that's coming from. It may be that that's the notice that the provider has given the RQIA. As I've said, the duty of care resides with the trust, and it's their responsibility to stick with those clients right up to the point where they're transferred, to another home. So the 16-day may be an approximation of what they think it's going to take to make those changes, but certainly in other homes that have closed, we've seen it being prolonged to maybe 3 or 4 months. So I'm not sure quite where the 16-day comes from. It's not a measure that I recognise particularly, but I don't know the circumstances in this case, and I'll certainly go back and have a look at it. But we have seen situations where people have been given 24 hours notice to leave a home, and it's just ridiculous. As you've said at the very beginning, this is a person's home, first and foremost.
So should there be a statutory requirement, therefore, to say that either to specify a reasonable period of time or to put the commitment on the department to find accommodation, and for those that this is a business and it's simply closing.
Yeah. There are regulations. The RQIA will have those regulations, so I'm not sure if there is a time frame. The most reasonable time frame I would suggest is about 3 months, 90 days, which is probably the most reasonable. Most people would see that as a reasonable time frame, but I'm not sure what has happened in the interim or how long ago the Northern Trust knew about that. So,
Mr. Dixon, the issue is that there's 23% reduction in the care home beds over the last 10 years. So being able to relocate, from the department's point of view, I think once we know that that's an impact on older people, and it's been, and the Department of Health itself knows that it's a impact.
Thank you. I think it's just down to the inability of the RQIA to read the room and read their own reports and see when homes are actually going to close.
Okay, thank you. Brian, please.
Okay, well, thank you. Welcome, Evelyn and Siobhan. And thank you for your paper is very helpful. Also alarming in places. The two charts there in terms of the demographics, the age groups. Northern Ireland currently has the lowest proportion of older people out of the 4 nations of the UK, and by 2050 we'll have the highest proportion. And yeah, our child population is already declining and will keep declining. Our working age population, so-called, has plateaued at best and is set to decline, and the older age population is increasing, which hopefully means we'll all live longer and hopefully live healthier too. But yes, there's and you've highlighted issues in that. One is concerning the number of care packages has actually declined over the past 10 years, and in a large extent our health services relying on immigrant workforce at every level, and we would be greatly lost without them. Do you have any recommendations, obviously, in terms of recruitment and training of more people, particularly for caring work? There's going to be increasing demand for that. I'm sure you're making that representation, that we need to do more.
Yeah. Something that I worked on in the past, which was a vision for nursing care and older people's services, and what needed to be done in order to make it an attractive career, as well as having the proper training in place. So I think the recommendations there were there needed to be sort of upskilling and focus, but it's all goes back to the overall strategic planning for an older person society, and getting the Department of Health to actually to future scope what the requirements are. So it's what's needed in terms of the training and development is there, but and there is ongoing recruitment within nursing, but the gaps, I think there's something like 1,700 gaps in nursing over across Northern Ireland at the minute. So I think the department knows what needs to be done. It comes down to resources and planning.
The fact that it's actually declining, the number of care packages, I hadn't seen that before.
No, it's actually indicated in the equality impact assessment that collectively, through the reduction in care packages, reduction in domiciliary care packages, and and care home beds it is having a detrimental impact. And those reductions, when the need is scaling up, is just it's a major cause for concern, which I think for the good planning we need to get in place in order to address that.
Yeah, well, these are issues we'll all continue to follow up. The other one, and of course the important contribution of voluntary care workers, and often within families, but also that's a burden on people, and they need to support those carers. The other one I want to highlight is you have a useful section there on support for older workers.
Yeah.
And and the law has changed now that you can't be made to retire. And that's a positive. And increasingly we will rely on people working beyond the statutory the age of the state pension. Those who wish to and are able to, again, some of our sectors will increasingly rely on that. Certainly that's an issue I'd be keen to promote, that where people are able to work, they should be helped to work, because our so-called working age population is declining, is projected to.
Yeah, well, I've been working for the last sort of probably 7 or 8 years on, age at work, issues, and supporting older workers to actually, to stay in work, because, we've got to be cognizant of concerns around, care and responsibilities, living with sort of certain long-term illnesses and stuff. But our research showed us that, maybe about a quarter of older people want to work, but then you've got the people that need to work, and you've got people that lost out during COVID, and contributing to pensions and stuff like that. So it's a massive thing, and dealing with employers, who are not necessarily looking at older workers. There's quite a low sort of uptake in terms of being really progressive about recruiting older workers, because I think that is the future of the workforce. We've less younger people coming in, but we've a highly skilled people that are dropping off the sort of employment precipice, if you like, because they're not the right flexibility, support for care and responsibilities, the support for phased retirement, all of that type of thing. So it's about us being there. I mean, it's the templates are out there, the good practices out there. I was working specifically on a 3 nations approach on this, so it is something we're very passionate about, but it's an absolute necessity for our economy to support contributions into tax contributions to support ongoing services longer term. I mean, at the minute we've 1 in 4 workers to 1 over 65. By 2040 it's going to be 3, and by 2070 it's going to be 2. So it's staggering. So we really, it's not rocket science what needs to be done. It's just a commitment to do it.
Yeah. And many older workers will not want to work full time.
Yes.
So they might want to do reduced hours, 2 or 3 days a week, whatever. I mean, there is the right, is there, to reduce working hours, or is there work to be done on that?
Well, I think employers are they are encouraged to be able to be more flexible, to to deliver, give more options, and they are being held to account in terms of requests from people to come in and get reduced hours and things like that. So I mean, as I said, the template is there. It's not rocket science. It can we can work on this and to support more older workers.
Okay, no, I'm sure we'll return to that theme again. Okay,
Yeah.
Thank you, Chair.
Thank you, Brian. And Timothy, please.
Thanks very much. Thanks very much for coming in. Very stark figures, very concerning figures you've outlined here. Year 2000, older people were approximately 13% population. 2024, 18%. And by 2040, 24%, which is nearly a quarter of our population. I think the most concerning ones for me was regarding dementia.
Yeah.
It's something that really stuck out, that in the next 2 decades it's going to double from 2020, 22,700 to 42,800 by 2040, and treble by 2050.
And the cost is going to treble?
Absolutely. So it's a case of the train's on the track, it's already moving, we know what's coming, but I'm not getting a feeling from the executive or the health department that they're preparing for what's coming down the line. The evidence is there, and it's quite clear that there's a shortage. You've mentioned 1,700 nurse vacancies. There's a shortage there already, but we're going to need a specialist team to deal with dementia. So it's not just general nursing, which there will be, but a need for. But looking at dementia as a specific sector within health, that's going to mean a massive recruitment drive and a massive amount of people needing to be trained to deal with what's coming down the line. And that's something very concerned about. Housing as well, and we hear about all the shortage for housing, but when the population ages, the type of house needing built changes. So we're talking about 100,000 new houses in 15 years. I presume there's none of them signposted to be bungalows, which will be a requirement in years to come. So the facts and figures are there. The Department of Health, Department of Communities needs to really grapple with what's coming and plan for the future on that. There's a couple of things I wanted to pick up on with you. You had said about adult safeguarding legislation. Obviously over in Westminster, assisted dying legislation is going through at the minute. I'm very concerned of the ramifications of what that would have. Very concerned about cohesion, people abusing that. The legislation seems to be falling apart as it moves along. I'm really looking at your thoughts and your take on that.
Well, it's a very divisive issue. I think we know that opinions are split across it. I think our role is to ensure that older people's voices are central to this conversation and any policy that would affect their dignity or well-being. But so they need not to be silenced. But this is not an issue exclusive to older people. You know, this is wide across the board. So we're consulting with older people at the minute to get their sort of views on what our priorities issues are, and whether this, you know, this. I've checked with the Commissioner for Wales. That wasn't something that was coming through over there in terms of their consultation. It remains to be seen whether it's picked up in ours. But I think for me the most immediate priority is making sure older people have access to excellent end-of-life care. The kind of care that allows people to die with dignity, comfort and support. And that's where I believe our energy should be focused right now.
Regarding the COVID inquiry, excluded from the inquiry in the main, if you had the opportunity to go in front of the COVID inquiry, what would your key messages be? Like in my office, I've heard from families that during COVID had to go and visit their relative, talk through a window. So at the start of COVID, dementia had started to play a part in the care they needed. When they weren't allowed in for 6 weeks, say when the home was in lockdown, the progression of dementia throughout that 6 week period was, I'm no specialist in the field, but families out there believe that because they weren't able to see and speak and spend time with their loved one, that dementia, that the process of that sped up because of the strict rules that were in place.
Yeah.
So I'd be interested in your thoughts. If you had the opportunity to go to the COVID inquiry, what would your key messages be?
I would like to come back to you on the dementia and the scale of dementia specifically, but I'm going to pass to Evelyn because she knows exactly what happened within the COVID inquiry and what was said. So please, if you didn't mind.
So the former Commissioner was a core participant of Module 2C of the COVID inquiry, and that was the one that was held here in Northern Ireland, and it was looking at government planning for all kinds of treatment of people with COVID, so like from start to finish kind of thing. And I was in the Commissioner's office during COVID, and one of the things that was really, really stark was the extent to which older people were not considered in the planning. And, you know, we were given privileged access to things like the surge plans and the plans for hospitals. And we asked critical questions about the plans for care homes, and there were no answers at that time. So I know that Eddie Lynch gave that evidence to the COVID inquiry, and much, much more. So I think we've taken part now in 6 modules of the COVID inquiry in written evidence in what are called Rule 9 requests, where they're asking us for information. And we've had a wealth of information to share with them. But the overall message of it has been Northern Ireland was no better than anywhere else preparing for what happened. Older people paid the consequences of that with their lives. And many, many people were bereaved, were excluded from their families during that time. I mean, you talk about 6 weeks. We have examples of people who didn't see their relatives for 9 months. Yeah. And many people would have said that during that time their relatives lost capacity to know who they were. Or they went downhill, you know, and a lot of older people died in care homes. I mean, the figures are very stark. The majority of the people who died of COVID in Northern Ireland were over the age of 70. And we could not possibly do that again. You know, if we are preparing now, as I understand the Executive Office is, preparing again for the next health emergency, be it a pandemic, be it something, you know, as critical as that, we have got to prepare better to protect the most vulnerable. I don't believe that if this had happened to children, we would have the passivity that we see now. And, you know, it also led to a massive rise in ageism and ageist narrative from many people, politicians, media, commentators of all kinds. I mean, I remember being horrified at hearing, you know, well, these people are like nearly 80, so their life is over anyway, you know. And we all know the value that we place on our grandparents and on our, you know, extended family members and how critical that is to our families. And, you know, Paula, you raised earlier on the issue of isolation. And many of the people who suffer isolation in Northern Ireland are not older people, they're younger people. And some of the residual family connectivity that we have here in this, you know, part of the UK is really critical. We have the advantage still of having tight, close families, multi-generational families who still live within very short distance of each other, and they suffered terribly during that time. So I think particularly what we did with care homes during that time, the lockdowns, the lockouts, you know, there were literally no witnesses to care in those care homes except the staff who were there. And the pressure that put on the staff at the time, some of it was really just outrageous. So
if there was a pandemic tomorrow, do you believe we've learned from the mistakes of the past?
I think we know the lessons that we have to learn. I don't think we've done the work to learn them properly or to activate, you know, a different set of provisions. You know, I think we all know what happened. It's as clear as day. And I've seen some work from the Executive Office in terms of the lessons that have been already published from the inquiry and what they're doing now about them. But if it happened tomorrow, I would have limited faith.
I have personal experience of, you know, having family members with COVID, you know, with dementia, you know, during COVID. So I know where you're coming from and what you're saying in this. I'd like to go back to the, you know, what you're talking about, the growth in the numbers of people living with dementia. I am a Senior Atlantic Fellow with the Global Brain Health Institute, and that's all about dementia prevention. You know, and that's where, you know, it's understanding that, you know, the impact of dementia can be delayed with the right, you know, sort of activities, that if people have their own self-agency or they're given the support to be able to get the right social connections, their physical activity, you know, monitoring their things like their diet, and there's a list of things that modifiable risk factors that can support people to delay the onset of dementia, which I think brings us back into the prevention agenda, where, you know, the healthy ageing sort of support for that within communities and through the Public Health Agency and through the sort of Department of Health is really critical, and that comes back to our strategic planning for an ageing society. And the same goes with housing. You know, we know it was a couple of years ago with the Northern Ireland Housing Executive published some statistics where, you know, there was like 70,000 Category A hazards in people's homes, and if the cost of of rectifying them would be in the region of sort of 40 million, but the reduction in falls prevention, which would then have the payback to the Department of Health, and that would be 8 years. So it's kind of understanding that cross-departmental. That's why we need that strategic planning from a cross-departmental to look at the, you know, what happens with loneliness if, you know, transport is affected. You know, what happens with loneliness if older people's groups are, if, you know, funding is affected. We just need to have that overview in terms of how it all works together. So I think that's why I'm encouraged by what the department has agreed, what you have agreed as an assembly, in order to plan for an ageing society and look at cross-departmental strategic planning.
Thank you. Claire, please.
Thank you, Chair, and Siobhan. You know, we've spoken a number of times. I'm really delighted by your appointment. I think even just listening to you in the last number of minutes, in relation to the wealth of experience and expertise that you bring to this role right across all various areas, you know, I think it's really a great appointment. Generally, I would say even the Commission has been a great support to my constituency office in relation to issues that we've raised and advocating even on individual queries, and I'm not sure people even recognise that work that you do as much. You know, we very much, you know, point this sometimes at the higher level policy stuff, but I think you do a really good job in terms of advocating for the individuals. So, you know, I want to, you know, note that, and you're probably going to get an influx of queries now. I suppose it's kind of just to come back to the point, Siobhan, that you've just made in relation to planning for an ageing society, and I think very much in terms of via my private member's motion, it aligns with what the Assembly has agreed to. It aligns, albeit loosely, with what we got in the final draft of the programme for government in recognising older people, and, you know, what that does not just directly for older people but indirectly across society and the impact on services. We need to look at our waiting lists and our housing lists to recognise that if we don't address this, those issues are going to become even more acute. So, you know, Chair, and I don't know how you feel about this or other members of the committee, I really do think we need to, you know, put pressure on the executive department to start work on an ageing population strategy. You know, even if we're just having that conversation now in the last couple of years of the mandate, you know, to really then begin, you know, the core work in the new mandate. I really do think that that's what we should be asking as a committee, because I think it is a cross-departmental area. You know, we've already talked to the various issues, and you know, you yourself have outlined at the outset that this is health, this is justice. It's, you know, it was Elder Abuse Awareness Day earlier this week, and you know, how we address that is even wrong. You know, we treat it as elder abuse when really it's domestic abuse. You know, so I would be putting it onto the table, or even as a proposal to this committee, that we push the executive on such a strategy if that's appropriate.
And I think, and Claire, to be fair as well, that there's been so much work done by the previous commissioner and Evelyn's team that on this Planning for an Aging Society, and the report that was published, you know, outlined some of the statistics that we're talking about today in terms of, you know, older workers and the impact on the economy, the, you know, reduction in, you know, in care packages, all of that. So we've got a good basis to start with, you know, that's, and then I do applaud the previous commissioner and Evelyn for what was done here. So, I mean, I do think that, you know, I would be really hoping that coming out of today, we would be coming back with, we do need to take this action forward. It's not just about saying there's a commitment, it's about what's our priorities, what's our actions, when are we going to plan for it, and how do we shape it, you know. So if we could get some sort of working group around that, the basic work has been done, it's been started.
Yeah. No, I think it's a great suggestion, and you know, I do want to push Chair back on the executive office a little bit, because to an extent I feel their mention of older people in the programme for government felt like a bit of a tag on, and I think certainly as a scrutiny committee we have to hold them to what that actually means and how it looks like in terms of tangible actions, and I certainly think what the commissioner has suggested is a great, you know, start to all of that. So I would be happy to propose that if anyone wanted to second that.
Yeah, the clerk has taken that down as an action then, so we'll do a regroup at the end. But yeah, no, thank you, Claire.
Thanks, Chair.
Okay. Sinead, please.
Good afternoon, Siobhan, and thank you very much for your answers so far. And can I add my congratulations? I'm absolutely delighted at your appointment, and I know that you'll approach every single day with enthusiasm and passion, because it's just in your DNA to do so. So I'm probably following up on what others have said, but I think it can't be said enough. Like the fact that older people were not prioritised really in the programme for government was really disappointing, but also it is really concerning, because even through our conversations today, there is not a government department that is not affected by our changing demography and our ageing population. I was on the economy committee this morning, and we were talking about our skills barometer, and we were talking about the sustained pressures and the future pressures that are going to be on delivering skills into the future. We were talking in a number of ways, but the fact that there is no prioritization in public policy to deal with the crisis that is ahead of us, and it's in lights in relation to our older population. Number one, how do we look after our older population, but also how do we look after our economy based on the levels of skills that are required, and all of that there. And it was right through, as everybody has said, from economy to health to communities to infrastructure and everything. We do not seem to have a sense of urgency about planning for this, even though that we know we plan for other emergencies that may or may not happen. But we know that this is actually happening, and we are not making, cross-government plans around it. So I would welcome Claire's suggestion there about, even that mapping. And I know that there's a significant work that has been done to date, but the fact that there would be a sense of urgency and mapping done to it, and it would be like an umbrella priority in the programme for government, which actually it did not appear, and hopefully now with your input that there will be a rethink in and around all of that. But
Sorry, Siobhan, Just to let the ladies, whether do you want to respond before she
I
moves
think,
on?
I think Sinead, you're absolutely right in terms of there's no mentions of older workers in the skills strategy for Northern Ireland or the 10x economy or the economic strategy. So that is something that we could build in, and I suppose I work with International Federation of Ageing. I'm the Vice President for Europe, and can I just assure the committee that we're not the only, the issues that we're facing in terms of planning for an ageing society is not exclusive to us in Northern Ireland at all. But what is exclusive to us, and I think which is the most progressive, is the fact that we've started with that commitment to plan, and we can be different. We can lead the way in this, which is the most inspiring and motivational thing for me. And I think I am really encouraged by what's been done so far. I mean, we all know how much there needs to be done, but give credit to what has been done and what's been committed to, and it's about us taking that forward.
Siobhan, you highlighted also in your report about the reform is essential in the health system. What specific changes do you believe are most urgently needed to make the system work for older people?
I think one of the big things is social care reform, and that's been talked about for as long as I've been working in this area, and I know that we've got budget, the Minister has said there needs to be stabilisation, but in order to get stabilisation, we need reform, so they sort of go hand in hand, and it is about creative thinking. We know that the resources are strapped. We know that, but there are models of best practice out there that can be followed, that we can be learned from. So I think, first of all, it is like, we talked about housing earlier on, we talked about ageism, but when I was looking at the difference between our ageing population, the issues there, but the rights and protections, we've put in place the Mental Capacity Act. We're working on that to improve it. They have the age discrimination legislation coming forward. The adult safeguarding legislation or the adult protection bill is coming forward. And awareness and prevention of abuse of older people needs to be heightened. We know that as well. But we are making progress. And I think that's to be, again, the Commission has done a lot of work to support that over the years. So again, credit where credit's due, but keep it moving.
Siobhan, do you engage with the Department for Health, with the Minister for Health at any point?
We've got a meeting. Yeah, we have a meeting in a couple of weeks' time, Sinead.
That's good. That's interesting. Yeah. And then sorry, go ahead.
Yeah, and we've also connections in policy level, like we're meeting with Mark McGuckin, the older people's, the lead there, and there's been lots, the Bill team, and also the adult protection team, and there's very good relationships built up there, and that's what we want to continue.
Brilliant. And you just mentioned at the very top in your opening statement about, you're in the post now 10 weeks and you've had multiple engagements and reached out, and you mentioned surveys and face-to-face. What steps are you taking to ensure that your engagement includes those really hard to reach groups now? And I'm talking about, people from our minority communities as well, and those in rural areas.
Yeah, well, we have been out in sort of rural areas, as quite a bit. The minority communities, there was, that is something that we will be targeting minority communities as well to make sure that we get their voices heard. So we've got a sort of plan for that too.
Okay, and anything that we as a committee can do to help, please come back to us.
Great.
Okay. Thank you very much, and good luck in your work.
Thank you.
Sinead, last but not least, Harry, please.
Okay, thank you very much, Chair, and Evelyn and Commissioner Casey. Thank you for your patience. Just a wee simple question: at what age do you become an older person?
Oh, no.
What age are we recognised as an older person?
Well done, Harry.
Isn't it the United Nations is like 50? But you look at, I've had a penny for the number of times I've been asked that question. I would be rich, but and then so we deal with people over 60.
Yeah, our legislation says 60, but the Commissioner does have the ability to deal with people younger than 60 if it's an issue. For example, some populations don't have the same longevity, or some people with disabilities, don't have the same longevity. So we can adapt to that, but it's mostly over the age of 60. And as I get closer to that myself, I am affronted. But yeah.
Okay. And Commissioner, after week 10, you're already making a difference. So, what's been your best reward so far in your 10 weeks?
I think it is engagement with older people.
Okay.
You know, I think, but you know, having like we did a lot of preparation for this meeting today, and I think it is actually also acknowledging the work that has been done to get us to where we are today, and that we're not starting from a blank sheet. You know, the commitments there from the Assembly, which we were delighted about last year when you passed it. We were disappointed, you know, in the programme for government, but that's up for grabs again, you know. So I think it's what's been done and engaging with older people.
So, you said over 50, so do you count us engaging with older?
A lot of
I know.
On the
What is
winter
it?
field.
Was it Oscar Wilde said, you know, what is older? Older is 15 years older than I am today.
There you go,
You know?
that's exactly right. On the winter field payment, I know you did mention, but I'm sure you'd welcome that, especially with, at present, I have noticed even this past week, like oil was sort of slowly coming down, but this past week alone, it's going up every day. So I'm sure that's something, I know you did mention, but you'd welcome.
Absolutely delighted about that, and I think it speaks to the importance of our older population and the need to listen to their voice. Yeah. You know, because I think the U-turn has, you know, demonstrates that, you know, older voters are critical, and I think, you know, we can all learn from that. Yep, more of us.
Thank you very much. Thank you, Chair.
Thank you. I think we're all feeling very uplifted from that nice positive session. I really appreciate your time, and just echo what everybody else said. Good luck in your role, and certainly if there's anything we could do as a committee, please come back to us at any time. Thank you very much. Okay, thank you. Okay, members, I'm going to move on quite quickly. Are you to leave, Brian? Do you?
Yes, I
Okay.
have to go now.
I think we're still quorate for a while, but we do have to go into private session for this next section. So thank you.
I just want to leave my card with.
Yeah, that's fine. Thank you.
Please, thank you.
Okay.
My mobile number's on that if you need it. Okay.
Thanks very much. Thank you, Evan.
I thought it was because he was the oldest member.
No comment.
Chair, can I ask a question?
Yes, please go ahead, Carol.
It's just the anticipated time for the end of this committee, because I have meetings as well. I'm going from one Zoom to another today, so.
I know. Look,
Are we in closed session?
We are in closed session now, yeah.
Sorry,
no,
sure we're not.
Committee Room 30, sound. 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 Committee Room 30, sound.
Okay, members, we're back in public session. We've just received some advice from the Head of Legal Services here in the Northern Ireland Assembly in relation to whether what would be the implications from us publishing our privileged legal advice that came to us as a committee body. And I am going to propose, on the basis of the advice we've received, that we do not publish. And I'm just wondering, is anybody willing to second that proposal?
I would.
Okay, Carol, thank you. And any dissenting voices? No. Okay, so do we need to put it to vote, or?
Chair, really, if there's no dissenting voices, a vote isn't actually required. If the committee is just content to make that agreement, that's fine.
Okay, thank you. Okay.
Sorry.
Please go ahead.
And what if someone wasn't here, Paula, and then comes back to try and put it to a vote? If the vote's already happened and taken place, then that's it.
Over.
I agree with you, but I'd like to ask the clerk to speak to that. Thank you, Kathy.
Okay.
Thanks, Chair. There is actually a process for that, to rescind a committee decision. So it can't simply be that it's proposed in another meeting and that a vote is taken straight away. If it's proposed in another meeting, then it actually has to go on the agenda to be brought back to a subsequent committee meeting, because all members have to be aware that it is something that you're reconsidering a decision, and therefore must actually have notification that is going to happen. So it can't simply just happen in the course of a meeting if it's rescinding a previous formal decision of a committee.
Fine.
Yeah, I think it would be dealt with as a substantive matter that would have to go on the agenda. Okay, thank you, Carol. Okay, members, will we move on? Okay, so last session we need to go back into closed session. This is around our final draft report of the gaps into equality legislation.
Committee Room 30, sound. 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 Committee Room 30, sound.
Public session. Okay, we're back into public session after the clerk has given us her assessment of what we need to do next with our draft report into gaps in equality legislation. So it was proposed that we, as parties and individuals, Claire, take the next 2 weeks until the 2nd of July to give one final review of the of our own party submission in the context of the report, draft report as it's sitting at the minute. That we agree whether parties, individuals submissions are added to the appendices, whether or not in September when we come back a minority report is that question is dispensed with one way or the other, and that in terms of the completed report then we will decide whether it actually speaks to what we were originally trying to achieve, and that was around the recommendations and the actions. So is everybody content with that way forward? Yeah, okay. Assistant Clerk, I wonder, could you please send us out as an email attachment just the report as it is at the minute?
Yes,
I always find it easier as opposed to looking at committee packs.
I'll do that.
And I wonder, is there maybe some sort of template that we can give revised comments to rather than trying to track changes in a document or... So I wonder again if you could, I know not all parties actually use the template you used before, but even just as possibly a guide about how we can maybe feed it in so that when we do that then it's easier for you to assimilate into the report.
Yes, that's fine, sure. I'll take that away and I'll just chat to the clerk assistant because she's done the latest draft and then come back.
Okay, everybody, thank you. So we have a lot of correspondence to get through. I'm just wondering, can we defer that or do we have to take that today?
It's totally up to you, Chair, but we could, a lot of them are grouped together, so
okay,
we'd go through them.
Okay, correspondence members, bear with me. Okay, so pages 119 to 128 of your pack for the summary of committee correspondence. So I'm just going to draw your attention to a number of items. 10.2, 10.3 and 10.4, it's the inquiry and redress scheme bill, access to records. South Eastern and Southern and the Western Trusts have responded to correspondence of the 23rd of May. You'll find these in pages 129 to 143 of your pack. And just to advise, those three health and social care trusts have responded to committee correspondence regarding access to records in relation to the bill in front of us. So just to advise that all the responses have been received, when all the responses have been received, members may wish to include an action to write to the Health Minister to outline how adequate funding will be necessary to deal with the increase in requests for personal information that are anticipated as a direct impact of the bill. I think that's something that you were sort of picking on today, Carol, wasn't it? Yeah. Okay. And so members will want to include an action to also ask the Health Minister what the Department of Health could do to improve the accessibility of personal information in relation to adoption. So just to ask you to note the correspondence and seek your agreement to further consider this when we have received information from all the trusts.
Yes. Produce under communities.
I think some of the the responses back from the three trusts there were in relation to how they're dealing with it, but that is a really good point then as well, Carol, in terms of, so we'll possibly just consider that at that time. So 10.6 then, survivors together, the response to correspondence on the 2nd of June in terms of social housing applications. So members, you'll find this on pages 152 to 155 of your pack. So this response was received from Survivors Together in relation to difficulties faced by victims and survivors when applying for social housing. So I'm asking you to note this correspondence, seek your agreement to write to the Northern Ireland Housing Executive describing the difficulties faced by, as outlined by Survivors Together. I wonder, but if this is more of a policy issue as opposed to a housing executive operational matter, maybe.
Yeah, it's communities, Chair. It's
Yeah.
not the housing executive just go on the policy set by the minister.
Okay, so we'll maybe take that back again then. Okay, 10.7, 10.8, 10.9 for Mana and Oma, Derry and Strabane and Causeway Coast and Glens District Council. So it's the response to correspondence of the 7th of May in relation to the local change fund. So you'll find these responses on pages 156 to 171 of your pack, and this was in relation to our correspondence regarding the local change fund, which is the local funding for ending violence against women and girls. So just to remind you, the committee team have issued a reminder to those councils that have not yet responded, and to date responses have been received from 7 council areas. So again, we're just going to note this correspondence and seek your agreement to consider further action when all of the responses have been received. Okay, 10.10 individual correspondence issues relating to translink transport routes. So you'll find this on page 172 of your pack. So just advise that the committee's received this correspondence from an individual regarding Ballymena's inconsistent bus service. So just to note this correspondence and seek your agreement to respond to the individual, informing them that this issue does not fall within the remit of the Executive Office and to forward their correspondence to the Infrastructure Committee. Agreed? Okay, 10.14 Northern Ireland Judicial Appointments Commission proposed dates for engagement session, and you'll find this information on 176 of your pack. So just to advise that the committee's received this correspondence from that Judicial Appointments Commission regarding potential engagement session with the committee and the Committee for Justice. So I'm asking you to note this correspondence and seek your agreement for the committee team to liaise with NIJAC and the Committee for Justice to arrange a suitable date for this session. Great? Great. Okay, the 10.16 PSNI invitation to the launch of the Race and Ethnicity Action Plan on the 7th of August 2025. So this is on pages 237 to 252 of your pack. So just to advise, the committee has received this information from the PSNI to the launch of their Race and Ethnicity Action Plan launch, and that's from 6 to 9 p.m. on Thursday 7th of August at Ulster University Belfast. They've also sent a copy of their Race and Ethnicity Action Plan consultation report. This report outlines the feedback that was received during their 8-week public consultation for the Race and Ethnicity Action Plan for 2025 to 27. Changes will now be made to the draft plan prior to its official launch in the coming months. So I'm asking you to note this correspondence, seek your agreement to and also to advise that if any members do wish to attend, you can register via the link in the invite. So 10.17 South East Fermanagh Foundation response to correspondence of the 16th of May, communication strategy for Troubles Permanent Settlement Payment Scheme. So members, you'll find this information on page 237 to 252 of your meeting pack. Just to advise, the committee has received a response to the committee's correspondence of the 16th of May requesting information on what CEF would like to see in the communication strategy for the Victims Payment Scheme. CEF has provided detail on what they would like to see for veterans and for the broader public inclusion of civilians, police, etc. So I'm asking you to note this correspondence, seek your agreement to further consider when responses have been received from all of the 5 groups. Great. Okay, so I'm just going to ask the clerk then to read into the record other items of correspondence. Thank you.
Thanks, Chair. Item 10.5 is the 41st report of the Examiner for Statutory Rules, and there are no rules to be drawn to the attention of this committee. Item 10.11 is a TEO news release regarding the recent disorder across Northern Ireland, which was emailed to members on the 11th of June. 10.12 is Department for Communities' response to the committee's correspondence of the 30th of May regarding HIA and complex needs points. 10.7 is TEO news release, new AI and digital office to drive innovation and transform services. And 10.15 is TEO response to committee's correspondence of the 7th of May in relation to budget allocations for ending violence against women and girls and the Strategic Investment Board.
Okay, thank you. Carol, have you had a chance to look at that correspondence in terms of the Strategic Investment Board? I know we're such a packed committee today, just wondering.
Yeah, I mean, I put a further question in, Paula, because it just doesn't cut it. I don't get why they just can't say much all this costs.
Okay, no, that's fine. Thank you, Carol. Go ahead, Claire, please.
No, just very quickly on the AI thing. Are we going to get a briefing about that in some point in the future?
We can liaise with the
Yes.
dialogue for next session.
Yes.
If the committee is interested.
Yeah, so I think there's contentment in the room there, and so the assistant clerk's going to liaise with the DALO in that space.
Yes.
Thank you. Anybody else want to raise anything under correspondence? No. Okay, so the draft work programme. So I'm going to ask the assistant clerk to speak to any changes, please.
Thank you, Chair. So it's just one update, members, and it's just to say that the programme for government has been moved now to the first meeting back after summer recess on the 10th of September, and that's just simply because officials won't have provided an update to the executive in that time, so by having it on the 10th of September they'll be able to speak a lot more freely. And just to say that in terms of the oral briefing next week with FM, DFM and junior ministers, that will be the second oral briefing that day from 3 o'clock, just due to prior diary commitments.
Yes, thank you. Okay, so we were just wondering then next week with the First Minister and Deputy First Minister and junior ministers coming, whether people would be content to maybe come about 15 minutes earlier, so we can maybe have a bit of agreement around questioning and you know how we get the most out of the session. So if you can go ahead, Assistant Clerk, and just let people know that that's been agreed who weren't able to attend or have had to leave the meeting early. Okay, members, any other business?
Chair, it's maybe not under AOB, but just in relation to the actions from the Commissioner. I had proposed that we take forward something to kind of press the Executive Office on an ageing population strategy. Sorry.
Okay, I'll just ask the clerk to speak to that. Thank you, Claire.
Sure. Yes, thanks. We do have that as a note to progress work on the ageing population strategy, and to note the disappointment about the older people, the mention of older people or the lack of thereof in the PFG, the lack of prioritisation that's been given, and the establishment of a working group to discuss that policy area. I think that's in a cross-departmental planning perspective.
Okay. I suppose I was thinking even more like a committee motion, or even just writing to the Executive Office to ask them specifically around a strategy, if people were up for that.
Yes. Yeah, that's fine. Yeah. We can maybe come back to a motion then once we investigate a bit further. Sinead, go ahead, please.
Chair, I'm just letting you know, next week I'm going to have to join remotely as well, because the Economy Committee again is visiting, and it's visiting my constituency. So I will be able to break away and join remotely, but that's the reason I'll not be attending in person.
No problem. Thank you, Sinead. That's been noted. Okay, members, time and place next meeting, say we could come a wee bit earlier, but apart from that, the meeting's adjourned. Thank you.
Committee Room 30, sound.